All right, the appearances are as before, and I did review the materials that were sent, and who had the floor?
Well, I think there was an objection, and I was asked to respond at some point.
I don't think anyone really had the floor the last time we left, Judge. It was simply the state had inquired that they would do some research, send over cases. We've received the cases, reviewed them. So really, I guess it's up to the court who you'd like to hear from first.
Well, I'll let you lead off, Mr. Gridley.
Thanks, Judge. So the first thing I want to make clear is that I hope the court will draw a distinction between two types of evidence Marquand Washington provides on this general topic of drug activity. One thing that Mr. Washington has provided to law enforcement and disclosed in a report provided to the defense is that the bonding between these two individuals occurred over drug dealing, that both of them recounted their activities with prior drugs, and I believe that in regards to the defendant here to be marijuana. So the defendant is purported to have said to Mr. Washington that he had connections in Detroit and California, and that he used to transport hundreds of pounds of marijuana back and forth to California. So, that would be historical information, which would be the defendant's side of the reporting that Marquand Washington said, I was also describing my activities with him. That's how we came to sort of trust each other and reveal details to each other. So we didn't just bond over I think it was tuna that he said was the other way that they bonded, but because they were discussing mutual past activities. So that is one thing that I'm asking the court to allow. I do think there's some distinction between then what he reported about the direct circumstances that are revealed in this case, so this investigation, right? So things that are contemporaneous with our case. And Marquand Washington, and from the state's perspective, those things reveal to a jury that Marquand Washington has inside information that he would not have unless there was some confidence being expressed, right? So it makes his details about any confession more believable because he has details about other circumstances of this investigation that would not be readily available, okay? So those details are that the defendant had caught a case going back and forth from California, but not worried about it because there's not much, because it wasn't that much. So we know that the defendant had a pending case in South Dakota where he had transported pounds of marijuana from the West Coast. But it wasn't substantial. It wasn't hundreds of pounds. It wasn't even dozens of pounds of marijuana. So from this, I think it's 10 pounds, right? Oh, apologize. Well, it is an amount of marijuana that would, in the context of people talking about hundreds of pounds, would not be as significant. And I have I can tell the court what it is. But anyway, and as the court knows, Ms. Remsburg has also already testified. I accompanied him to South Dakota for a case. Now, this Marquand Washington doesn't know it's from South Dakota. He just knows he caught a case, and that in perspective, it's not a major deal. Again, it reveals a confidence, right? Reveals something that is not that's not available, for instance, in the criminal complaint, where it indicates he's been convicted of a case but doesn't provide any of the details about that. Then there's the piece about what he describes as the police raid of the defendant's home. Okay, so what Marquand Washington says is the defendant told me the police raided my home and they got a lot of money but a little weed. Okay, and of course what's found in this raid by the police search warrant search is 2 pounds of marijuana. It's the seeds the court saw in the picture that's in evidence, and more than $47,000 in cash. None of those details are in the criminal complaint. None of them. And I'm not aware of them being in any coverage that I have seen of this case. In other words, what was specifically obtained in that search warrant. We didn't charge the drugs, right? So it wouldn't logically be a part of our criminal complaint. But the $47,000 is also not in the criminal complaint. So Marquand Washington knows that fact without it being in the criminal complaint. And from the state's perspective, that provides me an opportunity to argue to this jury based on things that are in this investigation, not separate and distinct drug, cases, not a month ago, a year ago, whatever. It allows me to show that he has some credibility in having heard some confidences from the defendant, such that you might say to yourself that a person might get to a point where they might go as far as admitting some complicity in a homicide. So I'm going to suggest first that the state's decision-making in this case was really defined by the case State v. Dukes, which is one of the cases I submitted. And I think that the legal phrase that you hear nowadays is called panorama evidence. And I don't commonly use that phrase, but I understand it to be, as defined in Dukes and as I thought about this case, that you don't need another Acts motion if you are describing circumstances and conduct, and I'm including criminal conduct, that is being used to explain items that are of interest to a jury and would be important for a jury to understand. And so in the Dukes case, as the court knows, the prosecutor did not file another Acts motion. The prosecutor is introducing evidence of activities that were happening around a house that police believe is a drug house during the time period of around May 27th. The criminal case itself is about a search warrant that occurred on June 26th, so a month later. The defense, very strenuously, argues this absolutely should be another act. It's other bad conduct that you're alleging at this residence and connected to our defendant, and you are using this to show that he's in conformity with the same activity. In this situation, it has some similarity in conduct, so it's probably even more something that would be, at least on its very surface, the kind of thing that you would think might be other acts, right? Because it would be an identity type of thought process in terms of another acts analysis. But the court, in that published decision, of course, the Court of Appeals, indicates very strongly that they do not believe this to be other acts evidence. They don't do that based on the similarity. That's not their analysis. It's not analysis based on 90404. In fact, they reject 90404 being the criteria that you would use. Now, obviously, they do an analysis about whether it's unduly prejudicial, right? So, and I invite the court to do that in this case and to think about whether drug activity is something that's unduly prejudicial in a murder case, and whether there's any propensity sort of worries about that, and whether a limiting instruction, as is recommended in all the cases I cited to the court, is a appropriate and strong and considered a definitely helpful remedy in terms of any misinterpretation or misuse by a jury. Obviously, the state's aware it's limited in its ability to argue that and understands that we can't do that. But in Dukes, paragraph 31, from the state's perspective, is the crux of the case in terms of talking about all of that, and in terms of talking about whether, finally, it's unfairly prejudicial. It defines in paragraph 31, unfair prejudice arises either when the evidence admitted has a tendency to influence the outcome of jury deliberations by the use of improper means, or when it arouses in a jury a sense of horror or desire to punish. Now, I just don't think the marijuana business is such that is, at this point, a factor, particularly in a homicide case, with these egregious set of facts, with the pictures of blood that these jurors have seen. And then it goes on to describe the evidence that is outlined in this case and why they believe that it is essentially panorama evidence. They say the evidence presented by Carter, that's the detective, informed the jury of police surveillance at the residence, that the behavior they had observed was consistent with the operations of a drug house, and that they searched a car because they suspected it contained drugs purchased. And from that address, and their suspicions were confirmed. So what it does is it ties together why people did each of the things they did. It ties together why officers were appropriately making decisions they were at each of those stages. And it is used to bolster the particular allegation that the defendant, in this case, possessed drugs with intent to deliver at a location when the search warrant was found. Now, the things I've talked about are not actually direct. It is a case that stands for the proposition that for collateral but important purposes that meet an appropriate definition of relevancy, that the court can admit this panorama evidence without utilizing another acts analysis. And that's where that's where I was. I do want to talk about the question of other acts briefly, because the court certainly, before I cited these cases, was strongly inclined towards another acts analysis here. So I want to acknowledge that, and I want to talk about the cases that I think support admission of this evidence when the court considers the factors that are relevant in Sullivan. The case of Plymesser, court sexual assault case, right, 1992, talks about an ability to use other acts evidence to corroborate a victim's testimony. It's victim in that case, but really it is the reporting witness. It's to bolster a crucial witness to the state. It's to bolster and corroborate their testimony. So when I talked about a line of cases, that Plymesser case is an early manifestation of that particular situation. But the Dorsey case, and then I think even more particularly the Hunt case, also adopt that. The Dorsey case that I talked about is also another acts admission, and they're not just talking about a victim. They use language in Dorsey about the bolstering a witness's credibility. They say in paragraph 49 of State v. Dorsey, furthermore, to the extent that our case testimony operated to bolster CB's credibility, we have held that, and this is in quotation mark, a witness's credibility is always consequential within the meaning of Wisconsin Statute 90401. So the court knows that 90401 is relevancy, right? So I'm going to suggest to the court that when considering this analysis of whether these things are relevant, State v. Dorsey, which is a state Supreme Court case.
What paragraph is that?
Yeah, I'm sorry, it's paragraph 49 and then into 50. So that what I just read, what I just quoted is paragraph 50. I apologize, counsel. So this is a 2018 state Supreme Court case which defines a witness's credibility as always being consequential, which is one of the ways you define relevancy. So in this case, we have two witnesses whose credibility will be absolutely attacked in this case, and they're key cornerstones of the state's case. One is Marquand Washington. The jury issue here is he credible for any purposes that the jury can get a grasp on in reporting this individual confessed to me? Is he credible? And the evidence we're asking to introduce bolsters his credibility, which is endorsed by Hunt, Plymesser, and Dorsey in terms of in general. And Dorsey, the state Supreme Court, clearly said that if that is the case, it's relevant.
Well, I'm sorry to interrupt.
Okay, that's okay.
But I'm still struggling, as I was yesterday, was with you've got a individual who is accused of multiple crimes, who has made some kind of a plea bargain with the government to cop a plea to some lesser charges, and one of the ingredients in the deal is he's got to testify in this case. And so we know on the one side there is an enormous incentive for him to come up with something. And I'm certainly not suggesting there aren't many people under those circumstances who follow through and testify truthfully, and the government got a good bargain. And I'm not suggesting that the government shouldn't be in that kind of making those kind of arrangements with people. But in the end, you're asking me to find this jail inmate is more believable because more reliable because the defendant allegedly made some admissions to him about a crime that has nothing to do with what is an issue in this case. And I'm thinking, well, now, step out of the role of the DA for a minute. If you're looking around for a car and you stop at two different car lots and find vehicles that are substantially identical at the same price, and you know that one of the offerees is sitting in jail under circumstances such as this witness, are you going to consider him more believable because he's taken a deal to testify against somebody else on an uninvolved matter? You're going to consider him as the more believable of the two people you're dealing with? I'm not at your destination point.
Yeah, I'm certainly not, right? That is a valid argument, and it makes perfect sense as an argument about his credibility, and I'm certain the defense will cross vigorously on that and make a vigorous argument, and they should, right?
And it's a jury issue, and it's not for me to make.
And right,
the problem
it
comes at a price.
Right. So Judge,
introducing evidence that this man has committed a crime totally uninvolved with the crime charged in this case. That is specifically barred by statute, except in limited other instances. Go ahead now.
Yeah, so I think the court has very articulately expressed what the compelling argument is about whether he's believable, and I am indicating that the appropriate ability to argue that there are elements of believability. The court's watched this many times, and I'm sure did it yourself. The way you bolster the credibility of an individual who certainly would be questionable in those ways, a co-defendant who testifies against someone, those kind of things, right, is you show specific information that they would not know unless the things they were reporting is true, right?
Well,
so that drug raid I'm talking about is an example of that, right? So just so we're on the same page. And also, if it's a person who's not intimately connected to you already, right, then I think it's a valid argument for the defense to say, well, this guy's living with him for only 5 weeks. The inmate himself, Mr. Washington himself, says this guy was paranoid. He thought people were bugging his cell and things like that. He's not going to admit to this guy that he committed a homicide. What possible reason would a jury have to believe that? I think that's a very valid argument by the defense, right? And the reality is we have information that is offered by the inmate that this other activity that they mutually discussed is the reason that those barriers. You know, yesterday I said it was the icebreaker. So I respect and believe that all those arguments we just described, including the one you articulated, are totally appropriate, and the truth about how that could be answered, right? You know, considering that Marquand Washington may simply be telling the truth, Judge, right? Considering that this man might simply be telling the truth, to give the jury a chance to consider that based on the information we have, we would be having this discussion, right? So, and you know, in the Hunt case, which is the last case I want to mention about this, they talk about that other acts in this case. So this is another acts analysis, again respecting the court's discussion yesterday afternoon. The other acts in that situation are provided necessary background and to provide an independent source as to, in that case, the victim or the witness's credibility. So again, it's about the victim or the witness being someone whose credibility can be assessed by a jury. Jury doesn't know. In that case, the witness involved was recanting, right? So the question is, was their original discussion credible? And it is, the other acts are admitted, and the question the question there is, can we use this for the very specific 90404 sub 2 purpose, not delineated in the statute, but where it says or other means, right, is to bolster, in that case, a victim and a witness's credibility. So here we have, you know, I want to mention the one last piece in terms of a witness, and that is the daughter in this case. So she has just turned 12, just a few weeks past her 12th birthday when she speaks to law enforcement. The defense argument in this case is that that 12-year-old has been coached, and that her mother has provided her information and put her up to the allegations. That 12-year-old in a recorded interview indicates that my father had me participate in several things. I saw that he went inside the car. These are the stalking allegations. I saw that the paperwork that had been taken from Rosalio Gutierrez's car in my father's house. I saw that he brought me along in the middle of the night, leaving the children, the 4-year-old twins behind, to peek into my mother's living room when Rosalio Gutierrez was over at her house. I'm being asked to spy on my father. All these things. He has concocted a false story that we're going to tell to frame my mother into a child neglect type of charge. And as part of what she says, Judge, as part of what she says, and ultimately she says my father was involved at his home, at the same place that the search warrant was done. He had a marijuana growing operation. He was manufacturing mushrooms. Here's how the marijuana operation was going. She mentions 72 plants. She actually knows the number of plants that were involved. She knows more, as I told you yesterday, about marijuana cultivation and the manufacture of these substances than I do as a 12-year-old. And she says he just harvested, he just essentially sold the vast majority of what he had. And when the search warrant is done, all of those things are true. We have all the seeds. We find 2 pounds of marijuana. There is the potting soil with the remains that are in the bags out in the back. Again, if she's been put up to this by her mother, then why is she able to be accurate about things we can independently confirm about that residence? This is very powerful evidence that this 12-year-old is a truth teller about things that certainly implicate her father in many, many ways in a homicide. So, and she also knows, Judge, the exact date that he will be going to South Dakota for sentencing on his multi-pound drug case. So she knows what it is, she knows what his offense is, and she knows the exact date, and that he will be going to South Dakota. And that date, by the way, is just about, it's the 27th, so it's a week and a half away from the homicide date. So this is not a 12-year-old who's being sheltered from her father's information or activities. She is being entwined in them in a way that, again, if those kinds of materials are not permissible, then she's being coached does not have that whole body of evidence available that shows that she got a number of things right. So how would the coaching, doesn't that undermine this idea that she's not being truthful in these other ways?
Well, I don't want to jump over onto that.
Okay, well, I only tell you that because for me, it's a two-part, it's a stool that has both legs. It's Marquand Washington's credibility, okay, which of course will be under vigorous challenge, and it's a 12-year-old daughter's credibility, who will of course be under vigorous challenge because she says some things that are highly damaging to her father, the defendant in this case. So the discussions we're having are necessary evidence to bolster both of those two persons' credibility, and I believe they are admissible based on the things I've indicated. Thank you.
Thank you. Defense?
Yes, Your Honor, for starters, I want to talk about the fact that Attorney Gravely is arguing really two different things here, and I think the court was anticipating this a little bit yesterday afternoon when the court observed that this certainly does appear to be other acts evidence. The initial part of Attorney Gravely's argument was that Sullivan and Whitty are not part of this and that this really should be treated as panorama evidence. Now, I know that there have been many cases where that type of issue has permitted the introduction of evidence when the state can allege that it's necessary to put something into context. And in those cases where it is admissible, in other words, it's not other acts, but it's merely panorama evidence, it tends to be much less prejudicial and much more relevant in order to give meaning to other procedural or timeline aspects of a case.
Counsel, can you turn your mic on?
It is on.
Okay, speak.
I'm having trouble
People are having trouble
looking at the judge while I'm speaking sideways, so I'll move this way. I like to make eye contact with Your Honor, if that's okay. So, again, when we see these types of cases where the prosecution wants to offer evidence that will provide more meaning or context to facts surrounding, it tends to be on a timeline basis. And the case that Attorney Gravely was discussing, it was precisely that. It had to do with events that had occurred leading up to something that the prosecution was successful in arguing that it was necessary to do that so that the jury wouldn't be misled or something's taken out of context or being given a partial picture. Now, in this situation, we're talking about a wholly separate, categorically different type of evidence. And the reason that it's being offered, if we really are looking at it under this idea that it's to bolster the credibility of a witness, that falls within the other acts analysis. And I'll point to the case of State versus Fink, 95, Wisconsin 2nd, 330, a Court of Appeals case from 1995. That case dealt with the prosecution did file an other acts motion, and it was 1 week before the trial started. And the issue there was, given that was termed as an 11th hour motion, and the issue there was 1 week before trial is not enough notice for the defense to be able to anticipate that this will be what we always want to avoid in our other acts scenarios where Sullivan does apply, is a trial within a trial where the proponent of the evidence needs to present facts that the defense is entitled to adequate notice to not only investigate, work it into the theory of defense, work it into voir dire questions potentially, as we probably should have in this case, but also so that we're not straying too far from what the central issue is in the case. And that's why 90404 exists, is so that we're not bleeding over into a controversy that is not part of what we're dealing with. I want to point out that all of the cases that we've looked at that deal with the concept of bolstering almost universally involve sexual assault cases, or they're trying to bolster the credibility of a victim in particular. And especially some of the recent cases on that issue, as the court is well aware, both statutorily and case law precedent supports the idea of the greater latitude rule. based on the premise that when there is a sexual assault or a victim of that type of situation, the prosecution is given greater latitude to introduce evidence that would otherwise be barred as character evidence, inadmissible character evidence, for the specific purpose of painting the person as somebody who isn't as innocent as he might appear, to not put that particular aspect of it into isolation. And in those cases where there's been past allegations that have been investigated, or even past similar allegations against another person or the same person, the court should give greater latitude because of the nature of those types of cases and the nature of the victims involved there. So what we're really talking about here is the state hasn't provided notice, and that's why they're arguing, I assume, that this is panorama evidence, because panorama evidence doesn't require notice because it's less, by its nature, less prejudicial, right? Anytime we're dealing with somebody testifying about illegal activity, and I know we've had discussions about the fact that marijuana is not as vilified as perhaps it once was, it is still a discussion about illegal conduct, breaking the law. And there are many cases out there that talk about the fact that it's natural that it would draw opprobrium from the jury in those situations if it's not specifically tied to something very important to a theory of prosecution. That's where we look at the 90404 and the many exceptions to the character evidence bar. The court's familiar with all of them: motive, opportunity, intent, plan, modus operandi, those types of things that have traditionally been allowed as an exception to that character evidence bar. The important thing to note here is that, just in addition to what Mr. Gravely was arguing, and by the way, I understand that it's his job to anticipate what the defense might argue, but we haven't argued any of the things that he's saying what the defense theory is. I think that's up to us to determine what our theory is and how we argue it, instead of having him speak on the defense team's behalf about what he thinks our theory is. Even if, and I think it's significant that he's explaining how he envisions all of this to be relevant to arguments that he anticipates that we're going to make, that's precisely the reason why an other acts motion should be filed before trial. It's so that those issues can be worked out and so the court can perform a detailed Sullivan analysis and also determine the impact that this will have on the way that the proceedings occur. So it's clear that the state either thought that this was panorama evidence and wouldn't need to file that type of motion, but at the same time they're arguing that for the purpose of witness bolstering, which would theoretically fall under a 90404 analysis, that they should get it in that way as well. But another couple of points to note here. First of all, this information that the state is alleging that Mr. Washington could not have known about in any other way except for a statement from Mr. Anderson is contained in the criminal complaint for the Ozaukee County case. And in addition to that, I don't know that the state can prove that that only the media and only this one complaint were the potential sources of information from Mr. Washington. We're getting into speculation about how all that occurred. But a defendant's entitled to have discovery, letters from his attorneys, all types of information in his possession in the jail cell. So to just assume that the only thing that could have possibly been the source of this information and therefore makes this evidence so incredibly relevant is flawed at its base. The second part of that that's problematic here is that the state is alleging that because Mr. Washington knows all these details on this aspect of it, he must be believed on the heart of the matter, the root of what we're really getting at here, which is the alleged confession that Mr. Anderson did commit the murder. Again, the state would need then to prove more than just a conversation occurred, because the theory here is that he couldn't have known these other facts but for this conversation. And that's not the end of the inquiry. There's all types of other ways that this information could have been brought to light. So I think that the relevance and significance of the argument to begin with is somewhat limited as far as its overall relevance. But I think the court is correct in your assessment that this does not conform with what the appellate courts want trial courts to do when it comes to a clean trial with a clean record and without muddying the waters with a trial within a trial. So despite the efforts to declare this as panoramic evidence, I don't think it is. I think it is definitely other acts, and I think that the state's failure to actually, and it's interesting because I think I heard the term cornerstone of the case being used here, and if that were so, and if that's truly what the state had anticipated, the massive significance of this to be, then clearly there should have been a motion so that it can be litigated not on day 8 of a homicide trial, but beforehand. I also believe that, and I'll let Attorney Mueller speak on this, there was a specific motion in limine on this.
One attorney.
Yes, sir. Okay.
On a subject. Go ahead.
Okay. There was a motion in limine that was filed on this matter that I believe did directly address this this aspect of it, and the state raised no issue of intending to get into this in any way. I want to talk about some of the cases that were cited here, and I would point out that the Dukes case that the state relies upon does not address this concept of bolstering of credibility directly. The Dorsey case that talks about witness credibility is actually incorporating cite to another case called State versus Menez, which is 331 Wisconsin 2nd, 568, Wisconsin Supreme Court, 2011 or 12, I believe, 11. That case, again, was a sexual assault case where the witness that we're talking about bolstering the credibility of was the victim of the crime. Again, it's a completely different type of analysis. So I think to make a long story short here, we have a notice issue. We have the fact that I think there are some proof problems. The fact that the state is trying to portray this as, two legs on the stool argument, again, is anticipating quite a bit as it relates to what those credibility attacks will be. But that issue should also have required an other acts analysis. So we're getting a preview of the fact that we're going to have that issue with the defendant's daughter as well. So, I know that the court's very concerned about issues that don't stick to the point, issues that don't relate to what we're really here all about. And the fact that this is a distraction, it leads into other areas. The relevance that's being purported here is absolutely minimal, and it's an improper attempt to, again, in this context, to try and bolster this witness's credibility, who's not a victim of anything. Now, there are the cases that talk about the credibility of, let's say, a co-defendant or something else that is where there's a question with regard to that person's participation in the crime in question, where, again, and then we sometimes fall back on traditional methods of quote-unquote bolstering credibility, like prior consistent statements or timing of reporting and those types of things, completely absent in this situation. So this is clearly not something that should be permitted, and we object.
Thank you. Did you wish to respond?
Very briefly. So the cases I cited, Judge, draw absolutely no distinction between a victim and a witness. And in fact, a victim, as the court often says in here, is a complaining witness and has to be dealt with by law as a witness. So none of these cases draw a separate distinction saying a victim gets a different kind of break in terms of this. None of the cases I've spoken about specifically rely on any kind of special statutory extra considerations for sexual assault. And I did mention the South Dakota complaint, and I apologize, I was not complete enough about the details. So that was a September 26, 19 South Dakota arrest and the amount of marijuana the defendant transported and entered a plea to and was awaiting sentencing that was going to occur on May 27th, I believe 10 days after we alleged the homicide, was 26 pounds of marijuana. Thank you.
Thank you. Well, there are a number of observations. Well, commenting first of all on the source of the information that this witness might have, I do think you're skipping some steps in there when you say, well, he couldn't have found out any other way. Well, there's no evidence of that. It's certainly possible, and there are cases that I've heard that there have been very, very peculiar details about a particular homicide, for example, that the police don't give out to the press or to the general public, that they use later in screening out people who are making false confessions and the like, that they feel can be used to verify the truthfulness of what is being told to them. But even those, I've often wondered, how can you be so sure? You can walk around this building and you can pick up all kinds of things you have no business knowing from well-intended people, and you're the district attorney. I mean, anybody should be able to walk up to you and tell you anything.
And they certainly have.
But I mean, I don't think it's limited to people just coming to you. I think that there are people who tell me things that are none of my business. And but anyway, to me, when I hear the term panorama, I'm familiar with it. I've admitted plenty of that evidence in other cases over the years. I'm thinking of panorama of the case that's before the jury. I'm not saying panoramic evidence cannot include something that is more of a satellite from the incident that brings the charges, but I do think of it as generally filling out the panorama of what's being tried. I often state, and probably did in this case in my voir dire, that the objective that we seek through the trial process is to put the jury back at the scene of the incident and have them make their determinations based upon the fullest possible knowledge. And sometimes that involves letting in panoramic evidence. But on the other hand, when the term panorama becomes an excuse to further push out the borders of what exceptions there are to the general rule blocking evidence, character evidence, there's been a steady growth. There has been a steady growth, and it's been commented on by the appellate courts, usually in affirming it. But it is a problem that we need to be watchful about. I do think this is other crimes, wrongs, and acts evidence. And in this instance, one of the reasons that I make this statement is that the incident that you want this man to talk about right now is completely, totally, and absolutely irrelevant to the story of what happened with respect to Mr. Gutierrez on the day of his disappearance. It is relevant only insofar as it bears on whether the definition of relevance is something that makes more or less probable what what the evidence would be without it. I'm not quoting it well. But
including the credibility of witnesses.
yeah, well, you're quite right.
This fits the definition of relevance, but I don't mean to argue with the
well,
court.
no, that's if I make a preliminary determination that this does bolster the witness's credibility.
Agreed.
The fact that these gentlemen sitting in the jail would talk about baseball scores or football or women or alcohol or whatever, that's harmless, no problem. People can bond over all kinds of things. They could bond over, he looks honest. People saying things like that. He looks honest to me. He had an honest face. But when the, as I say, said a bit ago, when the price becomes admitting evidence of other activity, which, though tolerated and even embraced by tax-seeking politicians, it doesn't seem to me to bolster the witness's credibility. And the price it's coming at is to accuse this man of a crime.
So
that he is totally unrelated to that for which he's on trial now.
So I understand that the court is denying my motion to admit as to them swapping stories about their drug transactions.
You are using the exact term I looked up yesterday. Okay. Very perceptive.
But I want to be sure I understand the court's ruling fully because I'm going to instruct him. So what about him talking about what the defendant told him about the police raid of his home, where there's already evidence before a jury? They've already seen the pictures of what was in the police raid.
I don't know what he told him.
What?
I don't know what he told him. Maybe he said,
well, I'll make an offer to the court.
I had 50 pounds of heroin in the back room. The police never got, you know?
Here's an offer of proof as to what I believe he'll say because it's been disclosed, right? He says when the police raided his house, he says the defendant reported to him they got a bunch of money and a little weed. Okay? So again, this is already in evidence. The jury's already heard about that. So I'm asking permission for him to be able to answer that question. And because it has to do with drugs, so I don't want to break the court's rule. But from my perspective, that's a different piece of evidence, right? It's already been heard by the jury.
Assessment. What? I think that's true.
Okay, so now I understand. Thank you.
Well, that wasn't the imprimatur.
I apologize.
Imprimatur, a ecclesiastical approval of the. Let it be published. It translates as "let it be published." In the Catholic Church, it and may still be used as a Episcopal bishop's permission for something on the subject of religion to be published because it's not contrary to Catholic teaching. That's a long explanation.
So I assume Mr. Washington is here. I need to instruct him very briefly, this will take me a minute, that he is not to bring up anything about their mutual discussions about drug activity. If the court permits, he'll be limited to the question I just asked, which is what, if anything, did the defendant tell you about the police searching his home? Period.
I'll hear you briefly on that.
Yes. The admissibility of that evidence when it did occur before that's related to that search was admitted for a limited purpose, and that had to do with impeachment of another witness. That doesn't mean it gets to be used for bolstering purposes at a later point. But we have the same issue here in terms of that is all information that is contained in the criminal complaint for the Ozaukee County case, which is natural that Mr. Anderson would have had. But before we go too far and have the same issue again, I'd inquire of the court if your ruling as it relates to this discussion with Mr. Washington about the drug activity also applies to the discussion or knowledge that the defendant's daughter has about the same issue, because it will come up again, and I don't believe the court has specifically ruled on that.
You're correct. I guess I'm back at the same point. The fact that the defendant may have imparted some historical information in his discussions with Mr. Washington. I don't know that somehow is, especially information that would be already known to the police authorities. It doesn't really constitute the defendant entrusting to Mr. Washington the innermost secrets of his heart.
Isn't it a valid argument for the state to say that this is something that is is information that is confirmed by the rest of the evidence that the jury has heard? So just as each of the things that Mr. Washington says about other specifics about this case or this investigation, to the extent that they can be verified by evidence the jury has independently heard, doesn't that make them more likely to have been said by the defendant? Of course, you can counter that. You can say, well, you could get that from another source. That's, again, a valid response, but it isn't a disqualifying response. It is argument that is a valid and appropriate argument. Again, Judge, we're now talking about whether he can be questioned about something that is already in evidence in this case.
Yeah, I think that's the bottom line. You're correct. It is not in evidence for the purpose that it now is being sought, but it's not going to suddenly astound the jurors to hear this, and for that very reason, its prejudicial impact is diminished, and that is one of the factors for the court to consider. So on this, I'm going to say okay.
Okay, so I just need to briefly let him know, and then I'm ready.
Have him come over if he isn't here already.
He's here. I'll just go briefly.
Okay, you can go talk to him.
What about the Olivia issue? I'm sorry.
We'll cross that bridge.
Okay.
She's not names.
And hey, avoid names with respect
Yes.
Yes. Sorry.
to minors.
Judge, would you like Mr. Washington brought out before you call the jury?
That'd
So
probably
should the deputy
be
bring it now?
helpful. Yeah. Would you come down, please?
Yes.
Thank you. What's going on here? You may be seated. Good morning, everyone. A word about tomorrow. We're following the weather situation, and as you're aware, the weather forecasters have correctly predicted 45 of the last 3-4 storms, snowstorms. So they tend to overpredict because they don't want to get burned. And that's, I don't know what's going to do tomorrow. We're looking at the situation, and one of the things that we're thinking about is having a call-in or a call-out, one way or another, having telephonic contact with you. Around 7, maybe 8 in the morning tomorrow to tell you whether we're going to be in session. And I would tell you that it would be unlikely that court would not be held if there's less than about 3 or 4 inches of snow, unless it's blizzard and the roads are severely impacted. So we would generally press ahead, but we have to be realistic about the possibility that there'll be a problem. So is that a situation that wouldn't work for anyone? That if we, either by your calling in here or you being called from here, we let you know whether you should come in tomorrow or not? Anybody have any thoughts on that? Or a better way? Well, think about it, and we'll talk about it later as we get more updates on the weather. Go ahead, Mr. Gravely.
Mr. Washington, when last we were in court, I asked you a question about what, if anything, that the defendant told you about a police search of his house involved in the investigation.
Okay.
What, if anything, did he tell you about a search of his home?
Well, he told me that you guys had raided his house or whatever, and that you had found a nice amount of money and a little bit of weed.
And what did he tell you about? What, if anything, did the defendant tell you about where his house was, and did he describe his house to you in some way?
He told me that he lived in Mequon and that he owned his house. He said it wasn't big as everybody else's house, just a small little house, but he owned it.
Okay. Was there a time when you were observing the defendant when it appeared to you he was having a nightmare?
Yes.
And what do you remember about that incident?
I remember I was laying there the night before. I told him about it the next day, but I was laying there, and I was reading my book, and I heard him shout in his sleep before he woke himself up.
And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
And you're quoting as best you remember?
Yes.
All right. And so did you ever have a discussion with the defendant about this nightmare that you heard him have, or these words he said?
Yes, I did.
Okay, and so if you know, about how long after that happened did you bring it up to him?
I brought it up to him the next day.
Okay, and what did you say to him about it?
I pretty much told him, I asked him about the situation about that he was locked up about, and I told him that he was talking in his sleep or yelling about some stuff in his sleep, and he was like, "What did I say?" And I pretty much told him what he said, and he's like, "Yeah, you serious?" And I'm like, "Yeah, you said it." So I asked him a question. I'm like, "Did you do it?" Like, what, you know what I'm saying? "I think you did it." And we went from there.
And so what did the defendant respond when you said, "I think you did it," based on the nightmare? What did he say?
I told him to look me in my eyes and tell me that you didn't do it. And he jumped down from the bed and he looked me in my eyes and he said, "I did it." He said, "That's the reason I have the nightmares. I'm unable to sleep at night because I think about it all the time."
Was there a discussion at some point where the defendant said to you, "Is it that obvious?"
Yes, he did.
And so when did that come up?
Objection, leading. The very definition of leading.
Rephrase your question.
When, if ever, did the defendant say to you, "Is it that obvious"?
Objection. Same exact same question.
That's taught in some law schools that's not a leading question. Others, like the one I attended, say it is. So it's not firmly settled, but I do think in the final analysis it tends to suggest an answer, so the objection is sustained.
In the discussion that you had where he looked you in the eye and said he did it, what else did he say, meaning the defendant?
Well, after we had talked and I told him, I basically knew he had did it, because I've been around killers. I know killers, like, pretty much, and he seems like a killer. I pretty much asked him, like, how did you do it? What happened?
Judge, I'm going to object here.
He has no way of knowing who's a killer and who isn't,
Right.
other than where he has personal knowledge.
That was opinion.
Such as something he would have observed with his own senses. And then there's people who might make their statement based upon the hearsay that we talk about all the time, and that's not even been stated here. So he's making a judgment just based upon no basis at all, really, in fact, that would ever be considered admissible in a court. So please disregard that entire statement. Any question? Thank you.
So when you asked the defendant, how did he do it? What was said next? What did the defendant tell you?
Well, he spoke indirectly. Starting off, he wasn't pretty much trying to say everything that he did. I felt like he was held back, but he said that, well, if you gotta know a person, you gotta learn a person, you gotta be able to know, where they live, how they move when they leave, what they drive, and then he told me, one way of knowing when a person is going to be a certain area is GPS tracking, and he told me Amazon sold GPS tracking that you can put on people's car.
Did he use a phrase to describe the circumstances of his case?
What do you mean?
Did he at some point were you aware of a nickname that some people had given the defendant?
Yes.
And at some point, what nickname did you hear people address the defendant with occasionally?
A lot of times people would say Houdini or Zach Houdini, or just telling me about who my cellie was.
And and was this a nickname that you did you understand why this nickname was given to the defendant?
Yes, I did.
And why was it?
Objection.
What's the relevance?
What
of
on
his
earth is the
nickname?
basis?
Because of what the defendant's reaction is to the nickname. So my offer of proof is when the defendant
Wait,
was...
no, Judge.
Well, no, he's talking.
No, but I
He's
think...
talking.
Okay.
When the defendant was confronted with this nickname, he, according to the witness, there was a reaction that is relevant.
Judge, I think that we had, in fact, the court instructed us to not go into all of this arguing about evidence in front of the jury.
I think the last question was started with a why as a word. Why? Pardon me?
When the defendant was confronted with this nickname.
Why don't you start with a new question?
When the defendant was called Houdini by individuals, how did the defendant react?
He never denied it. He just would laugh it off or, just go on about his day.
And did the defendant talk about why people were calling him Houdini and describe, what that was about to you?
Yes, he said they called him Houdini because of his case, basically because he made a body disappear, they say, and everybody called him Houdini because of it.
And what can you say about how he was acting when he described that to you? Was he sad, regretful, just neutral? Was he proud? Describe his reaction as he had that discussion with you.
I think he was kind of like proud, but not really showing it. Like he kind of smiled it off. I mean, in jail, like you when you're around people, you got to have like this kind of name for yourself. I don't know. Everybody fighting the same battle in there, so everybody fighting different cases, and he kind of like know his case is big, and because of it, everybody know him. So he kind of like wear that jacket a little bit. He doesn't admit it to everybody, but he does wear the jacket, in my opinion.
Okay. And what, if anything, did the defendant tell you about the circumstances on how he committed the crime? So you've already talked about, he said it took a lot of work, you got to follow the person's patterns, trackers from Amazon, you said all that. So what did he tell you ultimately? Were any of the circumstances he told you about how he did anything?
Yeah, he ultimately pretty much just told me that.
Well, I don't want to hear testimony. He pretty much just told me.
Okay. Well,
I'm not scolding you. I'm just telling you. You can quote exactly what was said,
Correct.
but we don't want your
pretty much
conclusion pretty much told. Okay?
Okay.
And Judge, a witness is not going to be able to exactly quote. We're not computers, so he's going to say, "Here's what I believe I was told." Right?
Well, I understand. Your point is legitimate.
Okay, so
however, that's a flashing warning sign when someone states he pretty much said thus and so. You may be able to access the information you seek with a different question, but we're 9 days into this trial.
Yeah.
We don't want to ignore flashing warning signs.
Okay. So what did the defendant tell you about how he committed the case that he's charged with, and what the circumstances were?
He said that he had seen this person, and he said he stabbed him, and he blacked out. He said he stabbed him, and I just blacked out. And he said he eventually wrapped the body up in garbage bags and got rid of the trash. He threw the trash out.
Okay.
And I asked him, what did he mean by that? And I said, what, like dumpster or trash? And he said, once it's gone, it's gone.
What if anything, did the defendant say about whether after killing this person Well, all right. So based on what you've said, putting in trash bags, it won't be found. Did you ask him any follow-up questions about things like how he moved the body?
Yes.
Okay. And what did the defendant tell you about how he moved the body of this person?
Well, I asked him, like, I'm like, you did this by yourself, pretty much. Well, you did this by yourself, and he said yes. He said he took him on his own. He didn't have his help with his brothers, because you guys said that his brothers was involved with this. He said he did not have any help. He did it all by himself. And I'm looking at him like, okay, don't look, I don't know if he was telling me the truth or not, because he was not a big guy, but he said, you should have seen me before I came in here. He was like, I was real cut, I was healthy, I was strong. When I first came in here, everybody was calling me Superman. So I'm like, oh.
And did he say, other than his own strength, did he say any other reason why he felt like he'd been able to do it himself?
Other than strength and adrenaline, that's everything he said.
Now, did you ask him, what if anything came up about why he did this? Why would he end this person's life?
He said to get back at his kid's mother.
And what did he tell you any more about that?
Yeah, he said that he was angry with a bunch of different things, but he said she kind of bragged about this other guy and that she was happy. He didn't really want his kids around that.
Other than the details you've described so far, did he provide any other details to you about the offense or any other of the circumstances of this case, other than what you've said so far?
He didn't really speak much. He told me what he told me, but he did say, no case. I mean, no body, no case. And that was where he left it at, pretty much.
Now, when you were originally debriefed by the government, were you asked about whether you knew of any other crimes?
Yes.
Part of that? Okay. And that was back in 2022, correct?
Correct.
And did you bring this particular incident that you have told us you heard from the defendant, did you bring that up originally when you talked to authorities?
I thought about it, but I did not.
Okay, so can you describe to the jury why, if you had already been confessed to by the defendant, why, when you were debriefed in 2022, you didn't choose to share this with anybody, any authorities?
Initially, I didn't know if me being federal, that would be something that I could use, and then I also didn't want to deal with everything that came with it. Like
what do you mean by that?
Like being put out in the open, like over the news, all over the media, that comes with risk factors. That's a lot of stuff that I wasn't know if I was ready to deal with.
So, best you remember, had you told anyone about what the defendant had told you up until just a few months ago?
No.
Okay. So, do you have an attorney in your case?
Yes, sir.
And who's the first person that you decided finally to share this information with? Who'd you tell first, hey, I know some facts about what Zachariah Anderson did?
My lawyer.
Okay. And did you, and what were your instructions to that person? So when you told them, did you ask that person, hey, tell somebody this, or what happened?
I talked to him about, because like I said before, he asked me, what all did I know at this time? Like, are you sure you don't know anything else? And I pondered about bringing that up again, and I brought it up to him. I was like, well, I do know something. And he said he was going to look into it, and he got back to me, and he told me you really should speak up about it.
And after hearing that from your lawyer, did you, what decision did you make?
I spoke up about it.
During the time that you roomed with the defendant, describe his sleeping habits if you can.
He barely sleeps. That was one of the reasons we was able to get along. I mean, we both had different schedules. Well, he didn't sleep really at all.
Objection relevance.
What
Goes to the discussion of the nightmares that he had, and is a part of the discussion where.
Overall.
Go ahead. Go ahead.
Yeah, well, he barely sleeps, like I say. Before I got in the room with Zach, he had told me from the dribble, like, dude, if you snore or anything, I can't be sealed up with you. I'm either go to the hole or you gonna go to the hole, because I barely sleep at night, and when I do sleep, I like to stay asleep. And I'm like, okay, so being in a cell with him, it worked out fine. That's why we was pretty much good cellies, because I stay up all night and he stays up all night, so he goes to sleep first. By the time he falls asleep or drift off for a little bit, I fall to sleep too, and it's pretty much breakfast after that.
I have no further questions.
Cross-examine? As you wish.
So show this counsel to us before.
Can you hear me okay?
Yes.
Can you hear me okay? Okay. So
Counsel, we though
you
are
can't
not
hear
able to hear you.
thank you, Judge.
Blinking red.
What's that?
Speak again.
No. Is this on, Paula?
Must be a little better.
I'm sorry?
Gotta change the batteries. Do we know that? Thank you.
Thank you.
all right?
Sounds good.
Sounds good. Okay. So, Mr. Washington, I'm going to ask you some questions. If at any time you don't understand, ask me to rephrase it. I'd be glad to do that. Okay? I'm going to ask you some questions about your current federal case and some of the interviews you gave, okay?
Okay.
Okay. And if there's ever a time that you want to confer with either of the district attorneys before you answer, let me know.
Okay.
Okay? And maybe if you could, like, scooch up or pull the microphone up a little bit closer and talk right into it, because I know you're a little soft-spoken. All right? All right. All right. So I want to start with on October 5th, 2021, you were indicted in the Eastern District of Wisconsin, right?
Yes.
And I'm going to show you what's been marked as Defendant's Exhibit 246. Do you recognize that?
I do.
What is that?
Yeah, that's my indictment.
That's the original indictment
Yes, sir.
on October 5th, 2021?
I believe so.
Okay, and that indicts you and 13 other people in a drug conspiracy, is that right?
Correct.
And the drug conspiracy is a conspiracy to distribute both, and it alleges in the complaint, in the indictment, 280 grams or more of a mixture containing crack cocaine and 5 kilograms or more of a mixture containing cocaine, right?
Yes.
But of course, as you talked about on direct, the amounts were far greater than that, right?
That's what they said, yes.
So as part of this, you're going to enter into a plea agreement, which we'll talk about later, but you're going to enter into a plea agreement with the federal government, right?
Yes.
And as part of that, when they give you the plea agreement, they give you an attachment with all of the activities that you and all the co-defendants did as part of this conspiracy, right?
What they believe we did, yes.
And, well, it's what you're going to admit that you did, right?
Oh, yes.
So, because you can't enter into this plea agreement unless you admit your guilt, correct?
Correct.
All right. So, in this case, you and Brian Phillips and Gerardo Laro are accused, well, at least in the attachment to the plea agreement, of pooling money to buy kilos of cocaine, right?
Yes.
And just the three of you alone got more than 9 kilos, right?
Well, that's what they said, yes.
That's what they said. But that's what you know, right?
I didn't say I know that.
Well, you said to the district attorney on direct examination that the entire conspiracy did more than 30 kilograms of cocaine, right?
No, that was for me. That's what the drug amount they put on me.
That's just you. That's what they call relevant conduct, right?
Correct.
And that's directly attributable to you?
Correct.
Okay. And so you did that with Mr. Phillips, Mr. Laro, and others, right?
Yeah.
And you did that in the context of being a a gangster disciple, a gang, a street gang, right?
That's what they say, but we're not gang members, no. But yes, you could say.
Well,
whatever the paperwork says, yeah.
the paperwork says that, so you're going to have to.
I'm going to interrupt.
Okay.
Who is your attorney?
Matt Ritchie.
He's not here.
No, Mr. Ritchie is aware that he's testifying and is supportive of his testifying in this case.
Has the agreement with the United States been signed?
No.
Not a signed agreement, but not only has the U.S. attorney approved this testimony, but so has his lawyer.
But it hasn't gone to judgment yet.
Correct? No.
The attorney's aware he's testifying.
Yeah, I spoke to him yesterday
Not
morning.
just about what he allegedly heard from the accused, but also as to his own alleged criminal misconduct.
Well, I mean, he's aware if you testify in a case like this that there will be questions asked to you about. I mean, this is a attorney who has entered a federal agreement with him and was the one who coordinated his testifying. with us.
Some of the questions you're being asked relate to your own personal conduct that could expose you to criminal prosecution, and statements that you make can be used as evidence against you. Do you understand that?
Yes, sir.
You've got a pending case right now. It's not gone to judgment. It's not been resolved. You haven't entered a plea. You have an agreement to enter a plea, but until the judge accepts it, it's not going to, it's still a pending case. So you have the right to talk with your lawyer about any question that seeks information about your own personal conduct. Do you understand that?
Yes, sir.
All you have to do is tell me you want to talk to your lawyer, and you will be permitted to do so. You understand?
Yes, sir.
Any question about this?
No, sir.
All right. Go ahead.
Thank you, Judge.
So I'm going to object to the question of gang membership. I don't know why that would be relevant to this inquiry.
It will become relevant.
Go ahead.
Thank you. So the three of you were involved in conspiracy. Well, there was others too, like 13 total, right?
Yes.
And you shared an apartment, right?
That's what they said, but no.
You didn't share an apartment.
No.
Okay. To store, well, you stored your money and your drugs in an apartment, right?
It was an apartment that we all frequented, but
Right.
and we used from time to time because we dealt with the same people.
Yeah, I wasn't saying you lived there. You shared it to use it for drugs and money, right?
Yes.
And you also shared the same supplier, right?
Yes.
And you engaged in fronting drugs to other individuals to sell, right?
Yes.
And you also pooled your individual money to buy drugs, right?
I didn't do that, but people on the case did, yes.
But other folks in the case did?
Yes.
And you were kind of the head of the whole operation, right?
No.
No? Okay. So you would also service each other's customers, right?
Yes.
So you would share drug supplies and drug packaging and, is that right?
Yes.
And you would also share rental cars in order to service drug sales, right?
Well, that's what they said, but I didn't do that, no.
You didn't do that?
No.
Okay. So, and most importantly, you were designed, the whole thing was designed for you to protect each other from detection by law enforcement, right?
Again, that's what they said. That was their opinion.
Well, and so let me just get this straight then. When you go to enter your plea in federal court in front of Judge Edelman, you're going to deny that.
There's a few things that I am going to fight before I sign my plea, yes.
Okay. All right. Did you talk about that with Mr. Ritchie, your lawyer?
Yes, I did.
Okay. So that was the scope of the conspiracy, but they also had, as part of this indictment, by the way, I would move to admit defendants D46.
Any objection?
No.
Identify that by
It's a
literal description?
Yep, it's an indictment.
246.
It's
Yep.
the indictment?
The indictment, right.
Okay.
There's a superseding, but that different name. So that was the scope of the conspiracy, but also you had they had some controlled buys on everyone else that was in the conspiracy, including you, right?
Yes.
And between March 14th, 2021 and October 21st of 2021, they did multiple controlled buys with you, right?
Yes.
Totaling 38.7 grams of crack, right?
Yes.
And they did buys from 11 other folks, right?
Yes.
They also allege that you threatened one of the informants, right?
Yeah, they said I did, but that didn't happen.
And that occurred on July 10th, 2021, right?
I believe so.
Yeah, and so that was where you and Mario Johnson were out looking for this individual because you thought he was an informant for the police, right?
That was a lie as well. We already knew he was an informant for the police.
Okay. But you were driving around in a black truck with guns looking for him, right?
That also was a lie.
That's a lie. You're going to deny that when you go in front of Judge Edelman?
Yes.
Got it. Okay. Just want to make sure we're on the same page. All right. So this indictment in Defendant's Exhibit 246, which was filed on October 5th, 2021, you weren't arrested right away, right?
No. I was arrested, but not here.
You were arrested on October 20th, so 15 days later, right?
Everybody was, yes.
Right. And that was the day they did a raid on your girlfriend's house on Chicory Avenue in Racine, right?
My kid's mother house, Chicory Road. Yes.
Chicory. Sorry, excuse me. So, and there they arrested you, and they found a backpack with $24,000 in cash, right?
They did not arrest me there, no.
They didn't arrest you there,
No.
but they found the cash, right?
They found heroin money, yes.
Okay. And they also found a Taurus G3C 9mm in a small dresser in the closet of the master bedroom, right?
I believe so.
Okay. And that was yours, right?
No.
No?
No.
Okay. So now, shortly thereafter, the original indictment was filed on October 5th. And on November 2nd, they filed what's called a superseding indictment. Is that right?
Yes.
I'm going to show you what's been marked as Defendant's 247. What's that?
Yes, an indictment.
I'm sorry?
That is the rest of the indictment.
That's the superseding indictment, the second indictment, right?
Yes.
And, excuse me for 1 second. So, just about a week after they raid your girlfriend's house, you said they didn't arrest you right then?
No.
When did they arrest you then?
They arrested me on the highway.
Because you weren't at the house when they raided it?
I didn't live there, though. It wasn't my home. But when they did the indictments and they came and rounded everybody up, I was on the highway. Everybody else was at their homes.
Okay. So in the original indictment, they charged you with a conspiracy. First, I would move to admit Defendant's 247, the superseding indictment.
Well, subject to the question. So far, there hasn't been any questions.
We identified it.
He identified it.
Okay.
Received.
So the original indictment alleged a conspiracy running from January of 2020 until October 5th, 2021, right?
I believe so.
And also one additional substantive count of you delivering crack cocaine on April 21st, 2021, right?
Yes.
Are we talking about the original indictment, 246?
Yes,
again?
I'm going to compare them to, right.
Okay. So, Judge, I'm going to object to the nature of the question of comparing an indictment that no longer exists to the new one. I have no objection to getting into the new one, but why does the comparison matter in terms of this witness's
Well, I'm just going to
veracity?
assume, and correct me if I'm wrong, that that was part of the concession?
Well, no, I assume this will be, this is not an...
I'll make it relevant, Judge.
All right.
In the next question.
All right.
Well, I'm not comfortable with, just to apologize, Judge, I'm not comfortable with assurances I'll make it relevant. That's...
Well, so
I'm ready to pounce.
I'm well aware. I'm on notice. Thank you, Judge. So the superseding indictment then adds a count for you of felon in possession of a weapon, right?
Correct.
And they could have, if they wanted to, you're familiar with what a 924C is, right?
Yes.
So a 924C is a federal statute that charges possession or use of a firearm in relation to a drug trafficking crime, correct?
Correct.
And you've talked about that with your lawyer, right?
Yes.
And that contains a 5-year mandatory minimum consecutive to any other case, right?
Yes.
And if it's used, or if it's drawn, it's 7 years, and if it's used, it's 10 years mandatory, right?
I believe so.
Okay. So, but they didn't charge you with the 924C. They just charged you with the felon in possession, correct?
Hold on. I'm going to object to the relevancy of this. Again, what we have right now is that this is an indictment. I believe that I have it written down as dated November 2nd, 2021. So it predates anything that has gone on in our case. It predates any contact with our case. So why would whatever the maximum charges versus what the federal government charged him, why would that be relevant to his veracity in this case, to his being?
You're welcome to go upstairs if you want, but I'm hoping this will be brief, and you can remain down here if you prefer. Don't talk about the case, please.
So all that's relevant, but they're max. Am I wrong? So the basis of my objection is I don't think it's relevant what charging decisions the federal government has made, whether they could have charged something higher and have charged something lower. You know, that's the current inquiry. So if it predates this case or doesn't have to do with any cooperation agreement, so this is at the time of indictment, then I don't believe it's relevant. So the machinations of the federal government before they are in a plea sort of posture from the state's perspective are irrelevant. Certainly anything that happens after we have an agreement or they have an agreement is.
So the relevance, Judge, is that he knows what a 924C is. It's a very serious offense used quite often by the federal government as a lever to get people to cooperate. And he's not currently charged with it, but that is a very, very common occurrence in federal prosecutions where if you end up going to trial, then they add it on. And they also add on something called an A51, which doubles some of the mandatories. So a lot of that is left off the books, but everybody knows it's there.
Well, but the critical reason I'm admitting this evidence is that it bears upon any concessions which may have been extended to this witness to induce him to testify. And am I understanding you're claiming that this superseding indictment was submitted, was returned before this crime allegedly was committed?
The superseding indictment is before he ever enters any cooperation agreement. He is in no way in a cooperating posture. What we're talking about right now, the superseding indictment, is the charging decision made by the federal government when they are placing him in custody and beginning the process. It has nothing to do with cooperation from anybody, us or anyone else.
Well, I don't know that, and Mr. Birdsall has stated that it's not. He didn't. Well, I think he said sometimes they add these aggravating charges when you go to trial. So there's some leverage there to the federal authorities, and the question then becomes, and I don't want to get bogged down on this, whether the federal authorities are aware that the witness has information that the district attorney would desire.
At the time of this indictment, they do not. At the time
The superseding indictment?
Correct. Both of these indictments that have been talked about so far predate any information with the DA's office. Okay? Again, this is November 2nd of 2021.
Well, the filings predated.
That's when the filing, that's when the charging decision is officially made. There has been no discussion of our case in any way, shape, or form until January of 2023.
I don't think that's what the objection was. I think the objection was that 924C wasn't alleged in there. It's just lurking out there. It's lurking as a potential hammer that hasn't been lowered yet.
But it's a
But
hammer.
if
But
they go to trial, then oftentimes those are added.
But that could be just. I'm sure this wouldn't be stated, but it could be used as leverage just to prevent the defendant from exercising his trial right.
That's correct. That's exactly what it's used for.
It's what we do nowadays in the
I
criminal courts.
know.
Feels to me like that's an inappropriate question. To say you
It might
haven't
be.
been charged with something where if you exercise your right to a trial, you will get this extra piece.
Well, you're talking about what theory is or what reality is?
Reality. That how is that? How does that go to his credibility? He's allowed to go to trial. So something held over his head about whether he goes to trial is not commenting on his credibility as a witness.
We're not commenting on his credibility as a witness in that regard. What this all is shaping up for is why he's here today. And he's here today because he's cooperating. And he's cooperating because of all of these penalties and potential penalties. So the ones
but the possibility of being charged with these aggravating matters may be as much related to the desirability from his point to making a deal, but not this specific deal of assisting the district attorney in Kenosha.
That's true.
It might be a little speculative.
I can just have a couple of questions about it and move on. It's not a centerpiece of my cross-examination.
And it feels like he's either being asked to speculate on what happens in the federal system, and this is, as far as I know, this is his only venture through the federal system, so he certainly could not testify as an expert about I mean, it's speculative for him to talk about the federal system.
I'll ask him. We already know he has a lawyer. We already know he talked about it with his lawyer. I'll ask him. Well, I'll ask him what he knows about it.
He will be asked whether it's common. This was the question that was asked that I objected to. Is it common in the federal system for people to add this particular indictment, so you would face those consequences?
That was not my
How will
question.
he know what's common?
That was not my question.
Well, why don't we do this? Why don't you rephrase your question?
I will do that.
I'm open to some area of inquiry on this line, but there are many considerations that one might make when deciding whether to hasten to deal with the prosecutor. And I don't want to give the jury the impression that it relates to this case unless there's some evidence that it does relate to this case.
I understand. Yeah, I'll tighten it up. No problem.
Ask the jury to come back in, please. Do you need a break? Well, just let me know if you do. Rephrase your question, please.
Thank you. Mr. Washington, the superseding indictment, you said you knew what a 924C was?
Correct.
And they didn't charge you with that?
No.
If you went to trial, was it your belief that they could add that charge?
No. I wasn't worried about the gun because, like I said, I wasn't around the gun. I was on the highway.
Okay. So, but you have now a new legal hurdle, this felon in possession charge, right, with the superseding indictment, right?
It came with just a 2-point enhancement or something. They didn't charge me with the gun or something like that, but it's just an enhancement that they gave me for my charges.
Well, are you thinking about the sentencing guidelines or the actual charge?
The guidelines.
Okay. So we'll talk about the guidelines in a minute. Well, maybe we'll talk about them now. What you think is that the gun is only an enhancement under the guidelines, which are not mandatory, right?
I believe so.
Okay. But you understand that the superseded indictment actually is a substantive criminal charge against you for being a felon in possession of a firearm, right?
Correct.
Now the guidelines, I assume you did a guideline calculation with your lawyer, right?
We came up with some things, yes.
Okay. Maybe just maybe.
Got to speak into the microphone so everybody can hear, please.
Like I'm right next to you and I can barely hear you.
Yes.
Okay. So the sentencing guidelines, you understand, are a situation where they have a whole set of criteria to determine what a recommendation to a federal judge will be about your sentence, right?
Correct.
And those are just recommendations, but they're oftentimes followed. Is that your understanding?
No.
No. They're just recommendations.
Correct.
And in your case, there's those are based on having a look at your criminal history, right?
I believe so.
And then, so there's two aspects. One is the criminal history, and the other is the actual offense, right?
Yes.
And so they take the actual offense and they come up with what they call offense levels, right?
Yes.
And there's a base offense level for the offense itself, right?
Yes.
And in your case, the base offense level is 32, right?
I believe so, yes.
And so what you were talking about is you think it's an enhancement. What you're talking about there is an enhancement for having a firearm in the conduct of this offense, right? And so it bumps it up 2 levels.
Correct.
Okay.
That's what they did.
And so you not only have that, but you also have the actual charge itself, right?
I don't know if I got the charge on her. I thought the charge might have got taken off or something, but either way, I was fighting that charge.
As part of your agreement, yes, right? As part of your agreement, that charge is going to be dropped.
The plea that they offered me, the 10 years, yes.
Okay. So, yeah, that's, so,
I'm sorry, I missed that. What was his answer?
I
His
think
answer to whether it was going to be dropped? That with the offer of 10 years, yes?
I think that's what he said.
Okay,
that's correct.
thanks.
So, and what you're referring to is the mandatory minimum of 10 years for the crime of conspiracy to deliver controlled substances, right?
Right.
And specifically in the indictment, when they allege specific amounts, and I'm looking at page 2 of Defendant's Exhibit 247, the superseding indictment, when they allege 280 grams or more of crack or 5 kilograms or more of cocaine, you understand that those levels are specific statutory levels that kick in the mandatory minimums, right?
Correct.
And so those mandatory minimums are designed, well, the effect is that if you are convicted of that specific offense and you go in front of the judge, and even if the judge wants to give you probation or a minimal sentence, he has no choice but to give you the 10 years, right?
Correct.
And this is the first time that you've been in the federal criminal justice system, right?
Correct.
And you would agree that it's kind of a scary place for you to be, right?
I guess so.
Well, you're kind of worried about the 10 years. Can we agree on that?
Yes.
And you want to not get the 10 years if you can help it, right?
Yes, I don't feel I deserve 10 years, so yes.
Okay. And so I'm sure you talked about this with your lawyer, but the only way, the exclusive way to not do the 10 years is to cooperate with the government, right?
Correct.
And that's what they call, quote, substantial assistance, right?
Correct.
And the way it works, you tell me if this tracks with your understanding and your discussions with your lawyer, but you agree to provide substantial assistance to the government, and then they decide whether or not it's substantial, right?
I believe so.
And then they decide if it is substantial in their view, that they will file a motion with the court to go below the mandatory minimums, right?
Well, I believe so.
And unless they file that motion, you're going to get the 10 years, right?
I believe so.
So any cooperation you provide, whether it's a debrief in front of agents or testimony in live court, it better be happy, it better make the government happy, or they're not going to file that motion, right?
I believe so.
Okay. I mean, this is a discussion you had with your lawyer, isn't it?
Well, you've inquired about this several times, and I'm a little uncomfortable about your asking him questions about his communications with this attorney.
Oh, okay. Well, I will not do that anymore. I'll just ask him what he understands.
No, you won't. Don't move to something else.
Moving on.
We're talking about, there are some privileges in our law that, as a general statement, with some exceptions, communications that you have with your physician or healthcare treatment discussions generally can't be admitted in court without your permission. A conversation you have with a religious figure, like going to confession or some equivalent, depending on your religious beliefs, generally can't be admitted in court. Spousal communications, and that's expanded to other relationships now too. But there are some areas that can't be inquired into in court, including conversations that you have with an attorney who's representing you in a case. Generally can't be exposed in court without the a waiver by the defendant. And because the attorney is not here to consult with this man, I'm just going to ask that Mr. Birdsall go to another area, and that's what he's going to do.
Yep. Thank you, Judge. This superseding indictment is filed on November 2nd, 2021, right?
Correct.
You are in custody, well, you're in custody by that point. And you're somewhere in some federal holding place, right?
Correct.
Did you immediately come to Kenosha?
After a couple of months, once they transferred me here from down south, yes.
From down south?
That's because I told you I was pulled over on the interstate, so I was in Memphis.
Oh, I see. I didn't realize you were out of state. Okay. So it took a little time for you to get extradited back here?
Correct.
Okay. So when you do come back to Wisconsin, though, you come right to Kenosha, or do you go to one of the other federal holding places?
They brought me here.
To Kenosha?
Correct.
In KCDC?
I went to the county jail first.
Okay. And then you get transferred out to KCDC?
Correct.
All right. And there's a bunch of other federal inmates there, too, right?
Correct.
So you're housed, if I understood your direct testimony, for about 5 weeks from December 22nd, 2021 to January 31st, 2022, right?
I believe so.
Okay. And that's the period of time when all of the testimony that you stated on direct about what Mr. Anderson said to you and all that, that's when all that supposedly took place, right? Okay. So...
Yes.
So you get moved out on January 31st to some other place inside KCDC?
Yes.
And I believe you said in your statement to officers that it was some sort of classification change?
Yes.
What was the classification change?
Objection irrelevant.
Overall.
I'm a federal inmate, so our level starts at 4. So we initially not supposed to be back there with those guys, but they didn't have the space. And Zach had told me that I was initially going to get moved. Eventually, he was telling me to get my level lowered if I wanted to stay back there because I was a good cellie. But I was new there. I wasn't finna get tickets or go to the hole or mess up myself, so I didn't do nothing about it, and they moved me.
Okay, so you're a classification 4. I don't really know how this works, so how high does that go?
I'm not sure. I done heard people have 5s and stuff like that, but a 4, from my understanding, is supposed to be minimum status, something like that.
Okay, so 4 is minimum, but like higher is worse?
Minimum as well. Lower 2s and 1s or 2s and 3s are what they call bad, I guess. I don't know.
Okay, so it gets worse as you go down.
Correct.
Okay. So, but in any event, you move on January 31st to some other location within KCDC.
Yeah, correct.
All right. So then just a week later, your attorney, Mr. Ritchie, gets a letter from Assistant United States Attorney Catherine Helopka Ivory, right? It's what's called a proffer letter. You know that term, right?
Correct.
So sometime in that week is when you must have talked to your lawyer, right?
Objection irrelevant. when he talked to his lawyer and calls
Well,
for
that question's all right. It's,
Not ask him what he said.
yeah, that's all right.
I believe so, yes.
Okay. So you finished with housing with Mr. Anderson. You talk to your lawyer, and 7 days after you leave his cell, you get this proffer letter from the government. Your lawyer gets the proffer letter, right?
I believe so.
Okay. So, and a proffer letter is an assertion by the federal government to say, we understand you want to cooperate. And if you do, we're going to sit down with agents and you got to tell us everything that you did and all the information you want to share, right?
Correct.
And what the letter says, it's I don't know if you ever heard the term transactional immunity. Have you ever heard that?
No.
Okay, so, but essentially, they agree to not use anything you say in that meeting of you giving information against you, right?
Correct.
And it might be commonly known as being king for a day. Did you ever hear that term?
Objection, Judge.
No.
The circumstances of this immunity are irrelevant in a proffer letter. Relevant.
They're directly
Depends.
relevant.
And I don't know, I've never seen it, so I have no idea.
Well,
Uh,
I'm going to show you what's been marked as Defendant's Exhibit 248. Is that the proffer letter that your attorney was sent you, or was sent?
I believe
Well, your
so.
question's unclear.
Was this the letter that was sent to your attorney, the proffer letter on February 7th, 2022?
I believe so.
I mean, I'll stipulate that it appears that it's a letter sent to the attorney.
Okay. Move to admit the Defendant's 248.
It's got highlighting on it, with or without the highlighting.
With.
Oh, is there a clean copy in existence?
We can print one.
Well, a form of that letter is admitted, unless there's objection.
Say it one more time.
A form of that letter is admitted unless there's objection.
No objection.
Okay.
Okay. So the letter, first of all, you went over this, or you were given a copy of this?
I believe so.
Okay. And so, and they say specifically that in exchange for your client's truthful statement, the United States agrees not to use any information furnished by your client during the interview directly against him in any civil or criminal proceedings subject to certain conditions and exceptions. Does that sound right? Does that sound about what you remember?
So objection, and this has been asked and answered. He already asked him, were you offered immunity, and I believe he answered yes.
All right.
Overall,
Does that sound right from your recollection?
Yes, I believe
Okay.
so.
So that was on December 7th, 2022. Not December, February 7th, 2022, right?
I believe so.
4 days later, on February 11th, you sit down with investigators Michael Seeger and Daniel Lagendorf and your lawyer to give information to help yourself on your federal case, right?
They came up and asked, said they wanted to talk to me, and I did agree to talk to them, yes.
Well, it wasn't just a chance meeting. This was set up by your lawyer and the government, right?
I believe so.
Okay. Okay. And so the whole purpose of advancing this cooperation that you were purporting to do is to get you out from underneath those mandatory minimums, right?
Objection, that's been asked and answered. He's already said that that was the purpose.
overall,
Yes.
So when you had the opportunity a year ago now, you sat down and you told them about a shooting at GRC Bar in Racine, right?
They asked me about a shooting, yes.
Okay. And that was where you and Mario Johnson and Akeem First were down in Vice Lord's territory and Akeem first gets shot, right?
He didn't get shot in Vice Lord territory, but the cop said it was Vice Lord's territory, yes.
Okay. But he got shot,
He did,
and you were there.
yes. We all were there.
And so you spent whatever amount of time it was sitting down with them to tell them that it was two individuals by the name of Andrian Harlan and Mark Geeter who were driving around and that they did the shooting. One of them did. Right?
They asked me about those gentlemen, yes.
And you said that you think one was driving and one did the shooting because you were there, right?
I was there, yes.
And,
Well,
oh, sorry.
the question and the answer were not totally congruent. You asked him, was he there and did he do the shooting? And he answered, I was there, yes.
I didn't ask if he did the shooting.
Or, you're correct, I apologize.
Yeah. So actually you said that Harlan was driving and Geeter got out of the car and shot, right?
I don't think I said he got out of the car and shot, no, because I didn't see that, but
Okay.
Yes.
And the reason you didn't see it is because you were across the street urinating.
correct.
And yet you still sat down with them and told them all of what we just discussed, right?
I sat down and told them what I knew of the incident because they asked me about it, yes.
Okay. And through that entire interview, just days after you leave Mr. Anderson's cell, you don't say a word about this supposed confession to a murder, right?
They didn't come asking me about that. They asked me about a certain situation.
Okay. So, all through 2022, you're in custody at KCDC, right?
Correct.
And all through 2022, your attorney is trying to negotiate with the government about your involvement in that conspiracy, right?
I'm not sure what he was doing in
What
the meantime.
conspiracy?
The drug conspiracy. Sorry. You're not sure what he was doing?
No.
Okay. Maybe you just didn't have a lot of contact with him?
We had contact, but we wasn't hearing anything. It was just a sitting point for us, really.
But you were looking to cut a deal, though. You didn't really want to go to trial, right?
I wasn't going to go to trial. Against,
sorry?
I wasn't going to go to trial against everything, no.
Because it was kind of overwhelming.
Correct.
And you understand that, and you understood that, you know, your only path forward was some sort of a deal, right?
Correct.
And so, flash forward to January of this year. I'm going to show you what's marked as Defendant's 250. This is a letter dated January 20th, 2023, addressed from the federal government, U.S. Attorney Bridget Schoenhorn to District Attorney Michael Gravely about your cooperation, right?
I never seen this, but I guess.
About you cooperating in this case. Is that right?
I never seen that.
Judge, he's just testified.
All right.
Yeah,
He's just testified he's never seen it.
Never seen it. All right,
Yeah.
that's fine. So,
Well, don't comment on the answer. He stated he didn't see it,
yep, all right.
and the objection sustained.
But but at some point prior to January 20th, 2023, you communicated to your lawyer that you wanted to come forward about Mr. Anderson, right?
Yes, I did talk to him.
Right?
Well,
I'll
talking
follow
about
up.
conversations with the attorney again.
No, this is what he's saying, not what the attorney's saying.
Yes, and?
Okay. Well, I'll cut the lawyer out. You, sometime in January of this year, so just a few weeks ago, advanced the notion or had it advanced to the government that you wanted to cooperate regarding this particular case, right?
Yes.
And you had just spent the last year wondering what's going on with your case, and so you're thinking testifying in this case might really help that whole negotiation, right?
Yeah, I brought it up to my lawyer and we talked about it, yes.
So that's a yes? You thought participating in this case, cooperating in this case might really help you in your federal case, right?
Objection, asked and answered. He said, I talked with my lawyer, yes. That's an answer.
Well, but there was, it had the taint of it that it was a reference, a conversation with the attorney, and Mr. Birdsall, I think, was trying to clean it up with the follow-up question.
Per the court's instruction, yes.
Yes.
Is that a yes?
Yes, I brought it up to my attorney.
Well,
to
we're
talk
not
about, yes.
concerned about that.
Forget about your lawyer for a second.
Okay.
You specifically wanted to advance your participation in this trial to help in your federal negotiations, yes?
If it could help, yes.
And you feel like it will help because this is a murder case, right?
I guess so, yes.
So, I'm going to show you what's been marked as Defendant's 252. That's the plea agreement, the proposed plea agreement that you were going to enter into?
Correct.
You have to speak into
Did
the
you
microphone.
inquire
Yes.
were or are?
Good
Was-
point. This is the one you intend to enter into, right?
That's the one that was brung to me, yes.
But the one that you want, correct?
I wouldn't necessarily say that's the one I want, no.
But it's the one you're going to do.
There's a few things I still got to argue in there, so I wouldn't say yes.
Okay. Well, but this is the one that's at issue, though, right?
That's the plea that's on the table right now, yes.
Okay. I would move to admit Defendant's 252.
Any objection?
No.
Received.
So in that agreement, it has some notable things, and that is, right now, as we sit here today, you're facing the conspiracy charge, right?
Correct.
The substantive delivery of crack, right?
Correct.
And the felon in possession, right?
I'm not charged with felony in possession, I don't believe so.
Okay, so I'm going to show you from Defendant's 252. Actually, I'm going to go back.
Counsel, I might have misunderstood your question as well. Are you asking him what he's facing or what the plea agreement envisions?
Right now, I'm asking what he's facing, and then I'm going to ask about what he's going to get from the
All
plea
right,
agreement.
so that's been asked and answered. He's already gone through the superseding indictment and asked whether Mr. Washington recognizes and understands each of the charges. So we've covered that.
So if I could, Judge, specifically, he wasn't sure. Just
Why
now.
don't you do this?
Yeah.
Ask him if he's aware of the difference in numbers.
In numbers.
Potential outcome.
Oh, yeah. Well, first I wanted to establish which charges are at play here. And so you weren't sure about the felon in possession. Is that right?
Correct.
Okay, so I'm going to show you page
Of what
24 of the superseding indictment,
Okay.
which is Defendant's Exhibit 247.
Again, we've covered this, Judge. We've gone through the superseding indictment. He's
Okay.
gone through each
His
charge.
he's
Yes, he's walked through each charge with him in the superseding
he's
indictment.
basing the question on other evidence as it relates to the witness's answer, which has most recently been given.
Correct. I'm going to show you page
overruled.
24 of Exhibit 247. This charges on or about October 20th, 2021, Marquand Washington, a.k.a. Munch. That's your street name?
It's actually irrelevant what his street name is.
It's part of the indictment.
Well, it's in the indictment.
Knowing he previously had been convicted of a crime punishable by an imprisonment for a year, for a term exceeding 1 year, knowingly possessed a firearm which, prior to his possession of it, had been transported in interstate commerce, the possession of which was therefore in and affecting commerce. Is that right?
Yes.
So that's what you're actually charged with right now as we sit here today, right?
I thought they dropped that, but
Well, that's what...
Are you saying it's already been dropped, or they're proposing to drop it?
I thought the plea arranged for that not
But
to
their
be
plea
in there.
hasn't gone through yet.
Right, but the plea that they had came to me with had removed the gun off there because I didn't get caught with a firearm.
The question is, because I asked you, if you recall, whether the plea had actually gone to court with the judge, and you had entered your plea, and I think you told me it had not.
Correct.
So you still have a pending charge.
Correct.
And until that time, whatever is charged in that indictment are the charges, in the superseding indictment,
Okay.
are the charges against you.
All right.
And I think what he's trying to do is to compare the potential outcomes between what you're charged with now, which will result in nothing unless the government can prove the case.
Right.
But if you're convicted, it could have a potential outcome. Or if you pleaded guilty, then you won't have any trial, and the judge will sentence you based upon your plea, which will apparently remove the firearms charge.
Okay.
So, but as it stands right now, if you were to go to court and you didn't plead guilty, the judge would have a trial, and the jury would decide based upon the charges that are contained in the superseding indictment right now.
Okay.
So I will show you what's already been admitted as Defendant's 252. This is the plea agreement, right?
Yes.
And so what it says is that the charge is count 1 that you're going to plead to, right? The conspiracy.
Correct.
That's the one with the 10-year mandatory minimum, right?
Correct.
The other 2 don't have mandatory minimums, right?
I believe so.
And then if we look on page 3, in paragraph 8 of that exhibit, it says the government agrees to, as part of the plea agreement, the government agrees to move to dismiss the indictment and the remaining counts of the superseding indictment as to this defendant at the time of sentencing. Is that right?
Correct.
And the plea agreement also has a provision for relevant conduct, right?
Yes.
And you understand that relevant conduct in the federal sentencing scheme, when you look at the guidelines, it's all driven by drug weights, right?
Correct.
And so the higher the drug weights, the higher the penalties, or the higher the guideline range, right?
I believe so.
And so in your case, they are, you're agreeing when you sign this, if you sign it, that the defendant is responsible for at least 3,000 kilograms, but less than 10,000 kilograms of converted drug weight. Is that right?
Yes.
And what they base that on is multiple different drugs, and they have a formula that comes up with that, right?
I believe so.
So, but specifically 30 kilograms of cocaine and 400 pounds of marijuana as part of your taking responsibility in the actual case, in the plea agreement, right?
Yeah, that's what they want me to take responsibility for.
Right. And they dropped all that crack stuff, right, as part of relevant conduct, right?
Right.
And your base offense level, you're agreeing, is 32 under the guidelines, right?
Correct.
So, but if we look on page 6 of this exhibit, just to be clear, 252, in the guidelines, you're a career offender. Is that right?
I qualify as one, they say yes.
Okay. And a career offender is somebody that
Objection. Again, why he qualifies as a career offender is not relevant to whether he's honest or not. So what he's charged with.
I'm not talking about why he qualifies. I'm talking about the effect of being a career offender.
Well, no, your question actually did.
I can rephrase. No problem.
Go ahead.
So, but if you sign this, you agree that you understand that the probation department, the United States Probation Office, they will do a guidelines calculation, right?
Correct.
And they've already told you that you're a career offender based on your criminal history, right?
Correct.
And so are you familiar with the guideline chart?
I've seen it, yes.
Okay. So I'm going to ask you if that's what we're talking about?
Yes.
Okay. And I'm going to move to admit, I believe, defendant's 253, which is the guidelines chart.
Is there objection?
No.
Received.
All right. So I'm putting it up on the chart here. So here we have two axes. On the left is the offense level, right?
Counsel, I'm going to approach just
Yes.
close enough so I can see this because the writing is pretty small.
Yeah, it is.
I apologize for approaching.
That's all right.
I didn't hear your answer. I'm sorry.
Yes.
Okay. So this is the offense level, and this is the criminal history category, right?
Yes.
And it's those two numbers that eventually find their way into a guideline range of potential imprisonment, right?
Yes.
And in your case, because you're a career offender, you're automatically in category 6. Is that right?
Correct.
Okay, maybe pull it,
Correct.
Yep. And under the plea agreement, you are looking at a base offense level of 32, right?
Correct. Correct.
Except because the offense that you're going to plead guilty to has a maximum of life, your actual offense level is 37, right?
No.
Well, it's one of those, if you're 32 in category 6, your potential imprisonment is 210 months to 262 months, correct?
Correct.
And that's your understanding.
Correct.
And so that is different than the mandatory minimums, right?
Correct.
The mandatory minimum would be 120 months, right?
Correct.
But you're potentially facing up to 262 as a suggestion to the judge per the United States Sentencing Commission, right?
Those are the guidelines, yes. But if I accept my plea, it's 3 points knocked down as well, so.
Right. Right. If you accept your plea, they take you down 3 points. So let's just do the math here. And we'll take you down to level 29, and that'll be 151 to 188.
Correct.
Is that your understanding?
Yes.
Okay. And by when we say coming down 3, that's called acceptance of responsibility, right?
Correct.
And that also is a motion by the government to take that down 3 levels, right?
Correct.
And so on 2 levels, in 2 categories, you're depending on the government being pleased with your testimony here today. Is that fair?
Yeah, I guess so, yeah.
Okay. Because on 1 level, you want to bring down your offense level for the guideline range, right?
Yeah.
And on another, and bigger and more important, is you want them to make that motion to Judge Edelman to get you under the mandatory minimums, right?
Yes.
Because, as you said, you just don't deserve it, right?
Correct.
Before you sat down with the government, they had advised, well, you knew that they knew about certain things you had done both before you were arrested and while you were in jail at KCDC, right?
What do you mean while I went?
Well, specifically that you and another person had threatened a confidential informant during the investigation of a case against you in 2020, right?
No. That's the same thing you asked me about earlier when you said that we was riding around with guns. That's what they mentioned.
Okay.
Correct.
So they're saying you threatened, and you're saying you didn't.
Correct.
Okay. So, and then in 2022, while you were at KCDC, they discovered you had a USB drive in your cell, right?
Correct.
Something like this, right?
Correct.
And that contained the discovery for your case, right?
Yes.
And there was the judge had signed a protective order specifically barring the copying and sending out of the discovery materials, right?
I never seen that, but
okay.
it wasn't
Well,
illegal.
they discovered you had it, and they confiscated it, right?
They came for something else, some pornography or something somebody else had going on, and they took it, and I haven't received it back. But I have been asking for it back because it is mine, and I can't have it. So,
Well, you can't have it because a federal judge entered an order saying you can't have it.
Well,
I never
Hold
received
on.
that order.
Objection. He has already testified. He doesn't know that.
He didn't let me finish my question either.
Well, but let's go back even a step back more. The discovery that you're referring to is the discovery in the federal court case,
That's
not
correct.
the case here.
That's correct.
All right. And
Could've
so
been clearer
why
about
don't you
that.
start over with a question?
Okay. So the USB drive you had in your cell was for your conspiracy case, the federal conspiracy case, right?
correct.
And you're saying you didn't know anything about the protective order.
Never got it.
Okay. You never, not to talk about, like you were never advised by anybody that you weren't supposed to have this?
Lawyer never mentioned nothing like that to me.
Okay, so because there's federal inmates at KCDC, they make arrangements, the federal government makes arrangements for defendants to have access to their discovery, right, in a separate room, right?
Correct.
And so how did you manage to get a USB with all of your discovery despite the prohibition?
We can buy them, but I bought an extra one from Mr. Anderson.
So you bought a USB drive and you went into the separate room to look at your discovery and you made a copy of it.
Correct.
Okay. So now that's been confiscated from you, right?
Correct.
All right. So in January, you had an epiphany about talking about Mr. Anderson's case with, so that you can get help on your federal case, right? We've established that.
Objections.
I'm sorry. I'd like to finish my question, if you don't mind.
Well,
I'd like to finish my question, Judge.
I'm objecting to the term epiphany,
Yeah.
which was the beginning of the question. It's argumentative.
Well, it's a word that's frequently misused. So I don't actually know what he's looking for. Epiphany means manifestation. And so I don't know. That's kind of a...
It's very peripheral to
You must have one of the brainiacs because that only they studied Greek when I was in school.
Okay.
Start your question over.
All right. So January, you decide you're going to advance the ball on Mr. Anderson's case to help your federal case. We've established that, right?
Yes.
Okay. So then on January 17th of 2023, just, I don't know, 3 weeks ago or so, you sit down with some police officers and the district attorney, right?
Correct.
Specifically, you were sitting down with all of the people at this table, right?
Correct.
To Detective Carrera, Assistant District Attorney Jessica, kept on your name, Krzarek, and District Attorney Michael Gravely, right?
Correct.
Those three people at this table.
Correct.
And also, Detective Warren Anschutz. Do you remember that name? There's another person there?
I believe so. I don't remember the name, but
Was your lawyer there?
no.
He was not there for this interview.
No.
Okay. But you sat down at the Kenosha County Jail, right?
Yes.
And you met with these three individuals for about an hour and a half?
I didn't count the time, but I
Sound about right?
I spoke with him, yeah.
Okay. And as you were being asked questions, who's doing the main questioning? Mr. Gravely?
Correct.
Okay. Was that like exclusively throughout the interview, or did the others kind of like chime in once in a while?
Everybody spoke up, yes.
But it was mainly Mr. Gravely?
Yes.
Okay. And he made it clear to you that he was very interested in having you come here, right?
He wanted to hear what I had to say, yes.
And that after you testify, he's going to report back to the United States Attorney about how well you did, right?
My lawyer said he probably would talk to him, but
Well-
yes, he didn't really, I didn't ask him that.
Okay. But that's what you're hoping for.
Objection, we've covered this area. What he's hoping for, asked and answered.
Overall,
What?
Yes?
Yes.
All in service of getting you out of the mandatory minimums and possibly the 262 months that in theory you face, right?
Whatever it would help with, yes.
In fact, the charge against you actually has a maximum of life, right?
If I go to trial, yes.
Well, whether or not you go to trial, it's still a maximum of life potentially, right?
Correct.
And so the guidelines say one thing, the mandatory minimums say another, and you're trying to get down to something where you can get back on the street, right?
Yes.
Just one moment, Judge. couple more, Judge. Mr. Washington, when you had the drive, this was actually, I'm just using this as an example, but when you got the drive, when you were in your cell, you got that from Zach, right?
Correct.
And in fact, you stole it from Zach. No?
No.
Okay. In any event, there was already material on it, right?
Zach removed the material from it and sold it to me, yes.
Okay. So if the government who seized it found that Zach's discovery was on it in addition to your discovery, you'd be surprised to hear that.
Yes, I will be.
Okay. I think I just need to move in.
I also sent money to Zach for that.
I just need to move in Exhibit 250. This is the proffer letter, or the letter to Mr. Graveland.
Is there objection?
No, no objection.
Received.
And that's all I have.
Thank you. Redirect.
Mr. Washington, is it your understanding that if you lie in a courtroom like this, your entire agreement is blown?
Yes.
Is it your understanding that if you give false information to the DA's office or any other place, your entire agreement is blown?
Yes.
Pardon me?
Objection. He's trying to bolster his witness.
Well, his credibility has certainly been an issue. Overruled.
So, if you tell a lie here, or if you tell a lie to law enforcement in a meeting, etc., then all of those consequences that were talked about by the defense are things you're going to have to face. Isn't that right?
Correct.
Nothing else.
Any question?
No. Okay.
All right, let's break at this point. Please don't talk about the case during the break. Read, watch, or listen to any account of the trial. Informational. We'll be breaking for the day around 2:30 today. Okay. Any questions, anybody? And I'll get you more information about tomorrow as soon as I get it. Okay, thank you. Are you aware of whom he speaks?
I am not. Can I release them or do I need to hold them?
No, let's move Mr. Anderson now, so you
Okay.
hold him just a few minutes. I'm going to get my phone. I called myself.
Hello.
Would you come down, please?
Yep.
Thank you.
We're up by 4 with.
Okay, now, all right, good afternoon, folks, and let's continue with the state's case.
They will call Caleb Petty to the stand.
What's our timeout?
61:59. We're up. We have 15 seconds.
15 seconds. Do you solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Would you have a second?
Ma'am, could you please state your name for the record and spell it?
Kayla Petty, Petty.
And Ms. Petty, did you know somebody named Rosalio Gutierrez Jr.?
Yes.
And how did you know Mr. Gutierrez?
He was the father of my daughter.
And from what year to what year were you guys in a relationship?
I would say the end of 2007 till 16-ish.
And what year was your daughter born?
2012.
And back in the time frame of May of 2020, was Rosalio involved in your daughter's life?
Yes.
Did he have her for some weekends of a month?
Every other weekend.
Did he take interest in her activities?
Yes.
What kind of activities was she involved in that he took interest in?
Dance and gymnastics, cheer.
And you indicated that he had essentially placement of her every other weekend. Was that the normal schedule?
Yes.
And did he do that every other weekend?
Yes.
I just want to direct your attention to May 17th of 2020. That would have been a Sunday. did Mr. Gutierrez have your daughter or placement of your daughter for that weekend?
Yes.
And so what was the plan in terms of him returning your daughter to you, if you remember?
He was to return her that evening, Sunday.
And do you recall if he did that?
Yes.
And back in May of 2020, what city or town were you living in at that point?
Twin Lakes.
So that's some distance away from Kenosha, the city of Kenosha?
Yes.
If you had to estimate, how long would you estimate it takes to get from Twin Lakes to the city of Kenosha?
I would say about 30 minutes, 30 to 40 minutes.
And so on May 17th, what do you remember about Mr. Gutierrez coming to drop off your daughter that night?
He showed up around 8:20. I remember that specifically because he was supposed to come a little later, but he did arrive earlier. Dropped her off, stayed not very long before leaving.
And was that the last time you ever saw Mr. Gutierrez Jr.?
Yes.
Since May 17th at roughly 8:20, 8:25 p.m., have you ever heard from him again?
No.
Has there been any reach-outs by him to your daughter?
No.
I'm going to show you a couple of pictures, so I'm going to direct your attention to the screen. This first one is on State's Exhibit 1, number 251, as soon as it pops up. So in this picture, on the left-hand side, can you see a pink note on a pillow?
Yes.
Irrelevance.
Do you want me to answer that, Judge? Because I can. The next picture. I'm now going to show you picture number 252. Do you see that close-up of that note?
I do.
And do you recognize who wrote that note?
Yes.
And who is that?
My daughter.
Your Honor, we already had a ruling on this issue. The defense had objected to this, including...
It's a standard objection.
Yes, you did.
Take it down off the screen.
Could we have a moment outside the presence of the jury? I can approach in a sidebar, Judge. I don't mind doing that.
Court of Appeals doesn't like those.
The handwriting on that note, do you know who wrote that note?
Yes.
And who wrote that note?
My daughter.
The 7th.
I have no further questions. Thank you.
Good afternoon. On May 17th, 2020, when Mr. Gutierrez was at your apartment or home, I don't know, you have a house, not really relevant, but were you able to observe what he was wearing?
I was.
And do you remember today what he was wearing on that date?
I do.
Can you please tell the jury?
Tennis shoes, a pair of athletic sweatpants. I do not remember his top.
Was he wearing a hat?
He was wearing a hat.
And was he wearing his glasses?
He was.
No further questions.
I have nothing based on that. Thank you.
Are you ready for the next witness, Judge?
Yes.
All right. The state calls Susan Brown Williams.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please be seated.
Ma'am, I'm going to ask that you speak into the microphone just so that we can have the maximum sound. This is a tough room to hear in. Can you do that for me?
Okay.
Thank you. Can you state your first and your last name and spell your last name for the record?
I'm Susan Brown Williamson. My last name is BROWN-Williamson.
And so how do we spell Williamson? Just so we have
WILLIAMSON.
Thank you. Ma'am, back during the time period of May 17th, 2020, did you own a residence in the municipality town of Belgium, Wisconsin?
Yes.
And was that at 309 Cedar Beach Road?
Yes.
And was it in May of 2020, were you trying to do some renovation or work on that property?
Yes.
Did you hire someone to help you with the demolition part of your renovations?
I did.
And is anyone that you hired to do some of the demolition for that property here in the courtroom today?
Yes.
Okay. Could you point out where the person is who was hired to do some of that demolition and just indicate what that person is wearing today?
He's wearing a grayish shirt and a suit and tie.
Can you point to that individual as well? Okay. Thank you, Judge. I'd ask that the record reflect that Ms. Brown Williamson has identified the defendant. Ms. Brown Williamson, in general, what was the work that the defendant was being asked to perform for you?
He was doing demo on an old house that preparing for a remodel.
And so what rooms of the house was the defendant involved in demolitioning for you or doing demo for? What rooms of the house? The whole house or just specific rooms?
The kitchen and 2 bathrooms.
Okay. And how was, to the extent that you know, how was the defendant accomplishing that? Was he using a vehicle, or how was he moving things out of that house for you?
So he was demoing and then bagging things up and using his vehicle and my trailer to haul stuff away.
And was your trailer something that could be pulled with a vehicle?
Yes.
Okay. Did the defendant do this work by himself, or did he have assistance, if you know?
Mostly by himself, and then sometimes he'd have a helper.
And about how many times do you believe he performed work at your house?
I would guess maybe 8 or 10 times.
And the 309 Cedar Beach Road address, where is that in proximity to Lake Michigan?
It's about a long city block off the shore.
And are there any state parks or significant parks in the vicinity of 309 Cedar Beach Road?
The Harrington Beach State Park is across the street.
I'm going to now turn your attention specifically to the date of Monday, May 18th of 2020. Did you have any contact with the defendant that you are aware of?
Not that I recall.
And when you had contact with the defendant, what were the means by which you and he communicated?
Typically phone text.
Okay. So you didn't utilize Facebook Messenger or any of those other services to contact or be in touch with the defendant?
No.
Okay. And is the defendant a person who in some way is connected to any of your children?
How we know Zach is we knew his brother before, so he's the brother of somebody who my son has known for a while.
Okay. And during the renovation of 309 Cedar Beach Road, what was the standard procedure if the defendant was going to do work at that location in terms of any contact with you?
We would often text. I might say I'm going to the house that day, or he might say he's going to the house that day. There wasn't a regular work schedule.
During the time period of May 17th and 18th of 2020, did anyone reside at that property, live there on a daily basis?
In 2020, no.
And was that a residence, again, in that period of May 17th through May 19th of 2020? Was it a residence that the defendant, Zachariah Anderson, would be able to enter without you being on premises? Did he know, for instance, where a key was?
Yes.
Were you present at that residence at one point when a search was conducted at that residence?
Yes.
Okay. And what do you recall about who was searching?
I got a call that Kenosha police were going there, and could I come there? And they had been there once before. It was just 2 or 3 officers that first time, and then I did go up there. I was on my way to Green Bay because my mom was sick, and so I stopped there on the way, and there were a lot of cars and a lot of officers, and there was a cadaver dog. And so I had to stay in the front yard. One of the officers stood and talked with me in the front yard. I couldn't go in or be anywhere on the property while they were there.
And in general, without asking any more details, how long did it appear that that how long were you there at the property while somebody was looking around or searching?
How long was I there? They were there before me, but so I'm not sure how long they were there, but I was there probably an hour or so.
When you left, were people still doing some sort of search?
I think I locked up.
Okay, so you think they were concluded when you left?
Yeah, somebody, the person with the dog had left a little earlier. I think he went to the park.
All right. I have no further questions.
Defense?
You had mentioned that Mr. Anderson was doing demo on your house, and you had mentioned something about him taking the debris back to his house.
Yes.
And do you know how he would do that?
He would use my trailer, an aluminum utility trailer, and he would use an old minivan that he had. He took all the seats and carpet and stuff out of it and was just using it like in lieu of a pickup truck, but he had a minivan, so he put all the stuff in there.
Did you say that he took the carpet out?
It was an old vehicle that was gutted, and then he used it to haul stuff from my, the dirty lath and plaster and all of the stuff that he was finding in the walls.
And to your knowledge, would he use trash bags to put the demo, the lath, the plaster in?
Yeah, he used big black trash bags and some trash cans from my property, and probably some of his own trash cans.
And then he would put it in the back of his van and then transport it back to his house because he had a dumpster there?
Yes.
Now, when on May 28th, 2020, when law enforcement was at your property in Belgium and you were there, had you, after they left, had you walked around your property?
I went inside. I went in and turned off some lights. I didn't go all around the whole property. It's only an acre and a half, but I didn't walk around outside much. I just closed the garage door and turned off lights and stuff.
Okay, and the time that you had walked around on that day, did you observe anything which was in your mind suspicious or out of place, out of the normal?
I can't think of anything. The cadaver dog tinkled in the basement.
Oh, okay.
That's it.
Okay. And then after this has all happened, have you been back to the property since?
Yes.
And from that day to the present day, have you ever noticed anything suspicious, out of the normal, as it would have related to why law enforcement was at your house on May 28th, 2020?
No.
I have no further questions.
Ms. Brown-Williamson, I think you mentioned the carpet in the van. You don't know anything about the condition of the carpet in the defendant's van, do you?
I don't think there was any.
You are indicating you are aware that that there was no carpet in the van?
Well, the last time I saw Zach, I was standing on the driveway, and the van doors were open, and there was a ton of stuff piled in there. There wasn't any carpet in there, I don't think. And then they closed it up, hooked up my trailer, which also was heaped. The back of the van was heaped with debris, trash bags and stuff, and then so was my trailer. But when I first walked out the back door, the van doors were open. The trailer wasn't hooked up yet.
Have you ever offered to law enforcement that you noticed something about the carpet being missing in the van? Have you ever said that to any law enforcement officer?
The only thing I said about the vehicle that it was gutted, I said that he was using an old van that he gutted to use for hauling stuff. But I don't know if I said that in person or over the phone.
Well, do you recall speaking to the Kenosha DA's office and not offering any information prior at the Kenosha DA's office about the carpet condition in the van?
I probably didn't mention specifically, seats or carpet or whatever else, but I would have just said it was gutted.
Okay. So your belief is that the last time you saw this van, it had no carpet in it. It was a van without carpet in the back, correct?
Correct. I don't think so.
All right. I have nothing else.
No further questions.
You may sit down, ma'am. State?
Yeah, state calls Andrew Schultz to the stand.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Schultz, can you state your first and your last name and spell your last name for the record?
Andrew Schultz, SCHULTZ.
And Mr. Schultz, how old are you today?
27.
What city do you live in?
Milwaukee.
And how are you employed in general?
I work for Primoris Electric doing asphalt.
Thank you. Back in the time period of May of 2020, did you know a person named Zachariah Anderson?
I did.
That person here in the courtroom today?
He is.
For purposes of the record, could you point out that person, indicate what that person's wearing today?
Nice suit over there, the blue one with the tie. Yeah.
And ask the record to reflect identification of the defendant.
Indicating the accused.
Would you describe the defendant as a friend of yours back in May of 2020?
Of course.
Okay. Had you, were you aware of what vehicles, if any, that the defendant owned and operated back in May of 2020?
I was.
What vehicles do you know that he owned or operated?
Let's see, it was probably 2010 Audi A4 and then a late 90s Dodge minivan.
Remember their colors?
Silver and black.
Okay. Which one was which, if you remember?
Black minivan, silver Audi.
Okay. And back in the time period of about May 17th through May 19th of 2020, which of those, if you know, was the defendant primarily driving?
Either or, usually. I really only saw him drive the minivan, though.
Okay. And who was the primary driver of the Audi during that period of time, if you know?
I'd still say he was the primary driver. If he let somebody else use it, that was his choice. So.
Well, did you know that he was letting someone else use it during that time period?
I knew he had a girlfriend that would drive it.
Okay, and was she the primary driver of it during that period of time, mid-May of 2020?
I still wouldn't call her primary, no.
When you were with the defendant during that period of May 1st through May 19th of 2020, what vehicle was he driving?
Either of them?
When you, during that period of time, May 1st through May 20, what vehicle was he primarily driving?
I'll say the minivan.
Okay. And did you know that the girlfriend was regularly driving the Audi?
I think she only used it once or twice, so I wouldn't say regularly.
You and I just talk about this case in my office with a witness present?
Yes.
Okay. Did you indicate to me during that period of time that you knew that the girlfriend, Christine, was primarily driving the Audi and that it had been lent to her because she had crashed a vehicle?
Yeah, I believe I said that, but you only asked if she had driven it a couple times, so.
I did?
In the office, yeah.
Okay, and did you tell me that you knew her to be the regular driver of that vehicle during this period of time?
If she only used it a couple times, I won't describe that as regular, but I mean, it's less than a month, so I wouldn't consider that a primary driver of a vehicle.
You believe you told me just a few minutes ago that she only drove it a couple times? That's what you believe you told me just a few minutes ago?
I'm pretty sure, yeah.
Okay. Mr. Schultz, when back on the time period of May of 2020, around again, May 17th, 18th, and 19th, when is the last time that you believe you were at the defendant's home?
Let's see. Was it the 18th? Tuesday?
Tuesday would be the 19th?
Then, yes.
So you believe it was Tuesday?
Yeah.
Okay. So Tuesday the 19th. About what time do you believe you saw him on Tuesday the 19th?
I would have been around 3:34 after I got out of work that day.
And how'd you get to his house, if you remember?
I drove.
Okay. When you got there, what was the defendant doing?
Just hanging out. I think he was burning some wood from a job he had done. So.
Okay, and where was he burning it?
Middle of his backyard, other side of the driveway.
Okay. Can we describe that as a fire pit? Would that be fair?
Yeah.
Okay. And what, if anything, did the defendant say to you about whether he had burning on prior days just before that Tuesday?
I think he said he was burning the day before.
Okay.
Yeah.
In the same fire pit?
Yeah.
And on the date of May 15th, so that would be Friday night, going into the 16th, which would be Saturday, where did you spend the night?
I slept upstairs in his kid's bedroom.
Okay. And on that date, how'd you get home on the, if you did you leave his house on the 16th of May?
I did.
Okay. How'd you get home?
He gave me a ride.
And what vehicle did you drive in, if you remember?
The minivan.
And was the carpeting in the minivan intact?
I did not inspect the back of the vehicle, but from the front seat, it looked just fine.
Okay. When you were taken home by the defendant on Saturday, was it just you and he?
Yep.
And in general, what location, like what city were you going to?
Back to Milwaukee, where I lived at the time.
Okay. And was the defendant using your address as well?
I had said he could use my address to get mail sent there for probation purposes.
And was he actually living at your address?
He was not.
How many times have you driven the defendant's vehicles?
Never.
Does the defendant, where does the defendant keep his keys to his vehicles?
I would assume on his person or in his house.
During the time period just before he got arrested on the 19th of May, how often were you seeing him, like, per week?
Maybe once, maybe less than once on average.
And how did you happen to be associated with him?
I worked for his brother.
I have no further questions.
Good afternoon. The state had asked you about when you were at Mr. Anderson's house on May 19th at around 3 p.m., asked about a fire that you saw going. Do you know if Mr. Anderson would routinely have fires going on in that burn pit?
Usually, yeah.
How frequently?
I'd say out of all the times I was at his property, probably 3/4 of the time there was either a bonfire or we were going to have one at some point.
And in your knowledge, if you know, you had mentioned, I guess, on direct that at that time you observed what appeared to be wood from a job site that he was burning. Was it oftentimes that he would burn things from job sites?
2x4s from like a tear out job, or he did chop down a lot of trees on his property, so there was always wood to burn. So.
And so it wasn't just it was used, he would use the burn pit, to your knowledge, as kind of a garbage disposal per se.
Yeah.
Objection, that's not a characterization. He said he used wood and logs. He didn't say anything about garbage disposal.
That's a leading question.
Judge, it's cross-examination.
Objection is sustained. Oh, it is cross. Okay, then I got to think about it. You can cover it on redirect.
Okay.
You can answer the question.
What was the question?
If he would use a burn pit to get rid of trash.
Well, yeah, it'd be easier just to burn wood than take it to a dump or put it in a dumpster and have it picked up. So.
And on May 19th, 2020, when this fire was going on, Mr. Anderson didn't tell you not to go by the fire.
Nope.
You could have walked up to it if you wanted to.
I usually do and throw other shit in it for fun. Stuff. Stuff.
What's kind of stuff? And you can be honest here. What's kind of some stuff that you would throw into it for fun?
Just other 2x4s if I had stuff in my car from other jobs.
And when you were there on the 19th, was the dumpster full, to your knowledge, if you remember?
I don't recall that.
Okay. And when you were there, and you were, I'm assuming, hanging out with Mr. Anderson, during that time, were you able to observe what Mr. Anderson was wearing?
I mean, usually just a t-shirt and shorts.
You just can't remember back that far? That's fine, understandable. But do you remember seeing him with any bloody clothes?
No.
When you were there on the 19th and the fire was going, besides the wood, did you see Mr. Anderson throwing out any what appeared to be suspicious items or anything else into the fire?
No, I did not.
And what time did you leave on May 19th, 2020?
I think I was only there for about an hour.
Okay. Do you remember law enforcement talking to you in this case?
After I had heard he got arrested, yeah, they came to they went to my parents' house looking for me, and then they came to my house in Milwaukee. So.
And do you remember them asking for your cell phone records?
Yes.
And you provided them your phone.
I didn't know how to pull up that stuff because I'm not great at it, but he figured it out, and it matched my hours book at the time for where I had gone. So
And in that questioning, did you feel as if law enforcement was trying to involve you in the allegations?
a little bit. It looked like they were looking for trips to Kenosha, but other than that,
And do you remember law enforcement asking you about whether you knew anything about a missing person from Kenosha?
I think they mentioned it. Yeah,
And you said you knew nothing.
had no idea.
I have no further questions for this witness, subject to recross.
Didn't you say you'd heard about it? Not that you knew anything about it, but that you'd heard about it?
Yeah.
Okay. When we talk about this burn pit, you've mentioned wood was being thrown in there, right? Yes? You got to answer out loud.
Yes.
Okay. Including construction wood, right? Like, whatever the stuff you do for demo in wood, right?
Yeah.
Okay. Did you ever see anybody throwing bleach bottles into the fire?
No.
You wouldn't have done that.
No, that sounds kind of dangerous.
All right. What about items of clothing? Like, did you ever see anybody burning any underwear in there?
Nope.
How about jeans?
Nope.
How about boots? Have you ever seen anybody burn any boots in the fire pit?
I have not.
Nothing else?
You didn't just live at Mr. Anderson's house and sit in front of that burn pile to see every item that was ever thrown into it, correct?
I did not.
No further questions.
Nope, nothing.
You may step down, sir.
Had a discussion off the record with defense counsel that they wish to at least make a challenge to some evidence that we think the court will have to listen to, at least briefly, because we're up to those witnesses. So I guess the good news is we're up to those detectives. But I fear that us starting and then the court hearing a very quick objection will not be helpful to the court. So we're prepared to call that witness, but I think it's probably going to be quicker if we have some sort of argument about admissibility first. I'm seeing a nod from defense attorney as well.
I take all that to mean you think it's best that we discharge the jury for the day?
Well, were we going to discharge them at 2:30? Was that the court's
were.
plan?
I think that's smart.
I think there hasn't been a discussion in this case that hasn't taken 15 to 20 minutes, Judge, so I guide you with that information. In fact, when I said 15 to 20 minutes, the jury was highly skeptical about that figure, that number. So,
in the Supreme Court, they've got a series of lights, and your time elapses when the light goes on. So, yeah.
If we have that, I'm ready.
Well, there's no sense. Actually, the biggest impediment is that I'm awaiting word on how to convey the news to you tomorrow about the weather. As I indicated, these people who panic at slightest snowfall, you don't look like people like that. So we're gonna tolerate some degree of snow unless the wind is really terrible and making it dangerous. But there is a point at which it does become impassable, so or very difficult or dangerous. So I think what I'm going to do is ask that you go to the jury room and wait word. The bailiffs will give you instructions as to what to do tomorrow, and or tonight, as whatever the instructions are. And in the meantime, please don't talk about the case. Read, watch, or listen to any account of the trial. Any questions, anybody? I was delighted to hear that we're moving along fast. I hadn't noticed. So let's ask them. Yeah, ask them if they do. Yeah. Wait upstairs, and then the bailiffs will discharge you. Any question? Enjoy the evening. can call the inline to tell them what to do.
Our next witness is Detective Howard. One of his many roles in this case, but one of the things he did in this case involved taking a receipt that was found in the defendant's van. The receipt had been badly damaged in terms of, it looks like elements, if I had to put a spin on it. And so visible on the receipt was the date and the time. Visible on the receipt was the date and time of the transaction, as well as Walmart, or enough of Walmart at the top to know that it happened at a Walmart. Detective Howard then went to our local Walmart here with that receipt, the partial barcode, the numbers at the top of the barcode, and the limited information you could make out. Utilizing an employee at Walmart, they then located the purchase at that date, at that time, giving them the Saukville Walmart's location as where the purchases were made. He was then given it's called an items history, or it's essentially a reprinted receipt, where it gives you the itemized history as well as the same date and time as the one he had, which then led law enforcement to the Saukville Walmart, where they then got the surveillance video. So we are offering him as obviously the person that facilitated all of that to then bring in the fact that they got the itemized history receipt to then get them to Saukville. And my understanding was that the defense's objection was going to be that they thought we needed the Walmart employee here to talk about the process, which is why I wanted to not argue in front of the jury about it, but bring it up to the court ahead of time. Obviously, we do have the physical receipts. We do then have the Walmart video that shows that, yep, there's the defendant, at least for purposes of the detectives that have viewed it, that is the defendant then making these purchases at that time, at that Walmart, consistent with the receipt that's generated and then turned over to law enforcement. So I believe it's, if anything, it goes to the weight of the evidence should be given, not towards its admissibility, but I wanted to broach that subject with the court first, as opposed to in the middle of testimony having that be something in front of the jury.
Judge, the defense of the position is that if you're offering a recording or a writing, that it has to be authenticated with the proper foundation in order to be admitted as evidence. This is evidence that the state intends to use for the truth of the matter asserted, for Mr. Anderson was at this Walmart at this specific time, and this is exactly what he bought. Although Detective Howard might very well be the detective who went and spoke with the manager at the Walmart, Detective Howard was not at all involved in the process behind artificially recreating the Walmart receipt, and that was something that was done by, I believe, the manager at the Saukville Walmart. Detective Howard had no part in that. Detective Howard cannot explain how that's done, to what degree of reliability that is. That is not anything that Detective Howard can testify to. Additionally, as the state just noted, it's attempting to introduce the video to show Mr. Anderson, their exact words was, at that time. And the only way that they can establish at that time based on the video is the timestamps that are in that video. And again, that's not something that Detective Howard can testify to, as far as whether the timestamp, that one, were the cameras were in working order, two, were the timestamps accurate, and three, what was the process of getting that information and then reviewing it and ensuring that that was in fact accurate information. These are all basic foundation principles.
Well, I agree with the general objection. Who's sponsoring this?
Judge, Detective Howard was with the Walmart employee asking them to run this check.
Right.
He's present for it. He's present through the entire thing where they're trying the different things to find this transaction. They then locate this transaction. The Walmart video is separate because that's actually a different detective that does that, who can authenticate the video from the perspective of, I was at that Walmart, I was in the parking lot, I recognized that parking lot, I went inside, I also spoke to and requested surveillance video. It is time and date stamped, which corroborates exactly the receipt that we retrieved from the Walmart.
This is testimonial evidence. It's testimonial evidence. The defendant has a right to cross-examine the source of the evidence. And the source is not the officer who collects it. It's the person, in the case of the receipt, who recreates it, and the whomever reproduced the video.
When you say reproduce, what do you mean? because they
Well,
they look
you
on their
got it
video
on it.
system and they make a
Huh?
copy. They look on their video system and they simply make a copy. So what do you mean by reproduce?
Someone who's going to sponsor it being what it pertains to be,
So
what it purports to be.
yeah. So the detective will say that he brought the receipt physically to a Walmart, and through looking at the Walmart receipt, he was then provided video that is matching that same time and date of the receipt.
And I suppose she made some reference to this. You might want some evidence to show that the times are actual and not.
Well, that
Well,
goes
it's off
to
by an
that goes to
hour.
wait. That goes to wait. We have the defendant's phone also present in that parking lot at the same
Yeah.
period of time. This is stipulated evidence. We have his phone at that location.
Why are these witnesses not available?
Well, they are witnesses we did not subpoena, so they're not on our witness list because we believed that officers are able to recreate this, as I've done many times over my career. So I apologize if the court feels that that's not appropriate. You know, this is no different than the doorbell videos we get in different cases, right? We don't bring a person to say, you know, that time on my doorbell video is correct. We simply have other circumstances where we match that typically. So if the court says, yes, you need that evidence, then we're going to ask the court's permission to subpoena those two additional witnesses, foundational witnesses. So our secondary request.
I think you need it.
Okay.
And you don't need my permission to subpoena them.
Well,
add them to the witness list.
Yeah.
Yeah, I don't think that's
okay.
a
So
problem.
we'll do that. So thank you for giving us an afternoon where we have time to scramble and get them. Yeah.
All right.
All right. We understand the court's guidance.
All right. Is there anything else?
No.
All right.
No.
Tentatively 9 o'clock tomorrow.
Okay.
Yeah, I'll give you some slack if there's weather that's such that it's going to slow you down. But if we're still going. Hello. Hey.